Good morning. Welcome to the Maryland Public Service Commission. The commission will come to order. Mr. Secretary, if you could please call today's docket.
Yes, Mr. Chairman, this evidentiary hearing is case number 9622 in the matter of an investigation of Washington Gas and Light Company regarding a building explosion and fire in Silver Spring, Maryland on August 10th, 2016.
Great. Thank you, Mr. Secretary. This hearing was initially noticed on July 16th of 2020 as revised by notice on August 31st of 2020. And this hearing is being held pursuant to order number 89550, which was issued on April 29th of 2020. In that order, the commission determined that it was necessary to conduct a trial type evidentiary hearing regarding the details of the Washington Gas Light Company's Mercury Service Regulator Replacement Program, which I will refer to as the MSR program throughout this trial. Additionally, the April 29th order described the limited scope of today's hearing. Let us begin by taking appearances of the parties in the order in which they will make their case. We'll begin with the Washington Gas Light Company.
Good morning, Mr. Chairman and Commissioners. This is John Dodge, appearing on behalf of the company. I am the Associate General Counsel and Director of Regulatory Matters. I would also like to enter the appearances of my colleagues Karen D. Hardwick, who is the General Counsel of the company. She is monitoring today's hearing on the Commission's YouTube channel. I would also like to introduce my colleague Paul Buckley, who is with us here in the virtual hearing room and who will play a principal role in today's hearing. Thank you.
Thank you, Mr. Dodge. We'll next to, was somebody seeking recognition? No. Okay. We'll next turn to the representative for counsel for the Apartment and Office Building Association of Metropolitan Washington.
Good morning, Mr. Chairman. Good morning, Commissioners. Exetral K. Caldwell, Senior Regulatory Counsel, for the Apartment and Office Building Association of Metropolitan Washington. Thank you.
Thank you. Good morning, Mr. Caldwell. Next, we have representative counsel for the Maryland Office of People's Counsel.
Good morning, Mr. Chairman, Commissioners. Joseph Cleaver on behalf of the Maryland Office of People's Counsel.
Thank you. Good morning, Mr. Cleaver. And finally, our fourth and final party, counsel for the Maryland Public Service Commission's technical staff.
Good morning, Chairman, Commissioners. Michael Dean on behalf of the Maryland. I'm an assistant counsel for the staff. I would also like to enter the appearance of Lloyd Spivak, who is also the assistant staff counsel.
Thank you, Mr. Dean. A few general housekeeping matters this morning. And Mr. Dean, if we could return your mute, thank you. It's important that you speak clearly for our court reporter today, who is making a transcript of this proceeding, and that counsel avoid any crosstalk on top of each other in this virtual environment. There is no need to rush through this administrative trial. We're going to take the time that is necessary to proceed accordingly. We have also reserved a second day tomorrow if we need it. Again, if you're not speaking at any time, please be mindful that your microphone is on mute to limit any background noise. And in terms of breaks and lunch, I'll take a 10-minute break every approximately 90 minutes, and we'll take a 30-minute break for lunch at an appropriate time this afternoon. Typical rules of conduct for this hearing. Regarding examination, witnesses' examination will be limited to direct, cross, and redirect. Cross-examination is limited to the scope of the direct examination of the witness, and redirect is limited to matters that are brought out upon cross-examination. If a commissioner questions a witness, counsel should have an opportunity to further examine that witness on the resulting answers. Participants on the same side of an issue may not cross-examine each other's witnesses on that issue. Additionally, succeeding cross-examiners will not be permitted to engage in repetitive cross-examination. An objection to a question put to a witness during cross-examination may only be made by counsel sponsoring that witness. And a request for clarification of a question on cross-examination may only be made by that witness, not counsel. Finally, a reminder This is a standing reminder that cross-examination is not to be used as a substitute for discovery. Questions on cross-examination that are designed to educate a party about the substance of another party's pre-filed testimony or otherwise obtain information that could have been obtained during the discovery process will not be permitted. Rules of conduct regarding the handling of exhibits. Every exhibit offered into evidence must be properly authenticated and have a foundation laid prior to the admission into evidence. However, I will waive that authentication requirement if the parties stipulate to the exhibit's authenticity. I do recognize in this case, many of the exhibits are currently within the custody of the PSC over the past 17 years. Those documents do not need to be authenticated. Parties are also discouraged from introducing discovery responses in lieu of any cross-examination of a live witness. Finally, because we're in a virtual environment, when an exhibit is referenced during this hearing, the examining attorney should make a specific reference if it is a pre-filed exhibit. This will help us, particularly the commissioners, find the exhibit, and we'll be taking just a minute or two when exhibits are called to find them. Let me pause there. Those are the standard instructions. Are there any questions based on those instructions? All right. I know we have a few preliminary matters. The first one is that we have the WGL, and I'll reference the utility as WGL throughout, a motion for leave to file rebuttal testimony, and the remaining three parties oppose the admission of the rebuttal testimony. WGL has asked for a brief opportunity to respond, and I'll allow the parties each a minute to respond as well. So, Mr. Dodge, I'll turn it to you.
Thank you, Mr. Chairman, and good morning again. This being calendar year 2020, I guess I should not have been surprised that the parties to this case opposed our motion for leave to file rebuttal testimony. Frankly, their arguments stand the traditional concepts of due process and administrative efficiency on their respective heads. The company bears the burden in this matter, and thus the company is entitled to the last word, if you will, from an evidentiary perspective. If we are not allowed to submit the pre-filed rebuttal into the record, we would expect to provide live rebuttal during these hearings. Accepting the pre-filed rebuttal is administratively efficient and does not prejudice any party. Since we are entitled to deliver rebuttal, we actually thought we were doing the parties a favor by pre-filing that nearly a week ahead of these hearings, so that they could form their cross-examination, something they could not easily do if we presented live rebuttal here today. Viewed from that perspective, again, there is no prejudice to the parties, quite the opposite. Washington Gas has been open and transparent about its response to the parties' direct testimony and given them the opportunity to question our witnesses about that rebuttal testimony. We also thought and continue to think that written rebuttal would serve the interest of administrative efficiency in that we would avoid lengthy live rebuttal here today. We are prepared and will request the opportunity to provide live rebuttal should the Commission deny our motion. That rebuttal would touch on many of the same points in our pre-filed rebuttal. It is simply more efficient to grant our motion. Let me address a couple of other points. AOBA argued that the company's motion is untimely, or that perhaps WGL waived our right to rebuttal. That is simply not so. AOBA does not cite any precedent in support of its waiver argument. Given the accelerated time frame of these proceedings and the changes parties have presented in their testimonies as compared to their prepared comments, it is critical that the company be provided an opportunity to rebut their testimonies. OPC's opposition acknowledges that the company has the right to close. The only question would be what form it takes. As stated earlier, providing written rebuttal nearly a week prior to this evidentiary hearing permits the Commission and all parties the opportunity to review our testimony. A live presentation would not present the same opportunity. Let me close with a discussion of the chronology. We received testimony from staff and OPC, particularly staff, but also OPC, that varied notably from the comments they submitted last November. Staff's testimony raised for the first time the possibility of a $63 million civil penalty in this case. We analyzed the testimony, we consulted with our clients and our experts, and ultimately we scheduled depositions in this matter, which required 10 days notice. The depositions were conducted on September 14th, 2020. After the depositions, we determined that pre-filed written rebuttal was indicated. We filed just 4 days later, again, nearly a week ahead of these hearings. We are unaware, Your Honor, of any commission precedent denying the party that bears the burden of proof the opportunity to file rebuttal testimony. We urge that the commission grant the company's motion. Thank you.
Thank you. I'll allow the parties who oppose a moment to respond. The first response I received was from AOBA. So, Mr. Caldwell, would you like to respond? Mr. Caldwell, you're on mute.
Yes, thank you, Your Honor. The issue here is one of timeliness. As we stated in AOBA's papers, there are at least 3 occasions where Washington Gas could have notified the commission and the parties that they wanted to file rebuttal testimony pursuant to long-standing commission practice. That's something Washington Gas stresses in its motion, that this is a long-standing commission precedent. They knew that this precedent was out there. Why wait until a Friday, the last Friday before hearing start to request rebuttal testimony? I'll just add 2 more points, Your Honor, and that is, if AOBA, who did not file direct testimony in this case, decided that AOBA wanted to file direct testimony based on some of the responses to some of the answers in the testimony of the parties, even my colleagues at OPC and commission staff would be upset with me. It's a question of timing. The last thing I'll mention is that in witness Tornini's testimony, he talks about tracking. On page 15, lines 18 through 19, he says, if the commission felt that tracking was needed, it had the opportunity to order tracking. I would make the parallel argument here. They should have asked for it in advance, and I'll leave it at that, Your Honor.
Thank you, Mr. Caldwell. Thank you, Mr. Caldwell. I should note that some folks' live stream has a stronger signal than others. Mr. Caldwell, we had a little problem hearing all of your testimony, but I think we understood the point that you were making. If counsel detects that they might not have a strong signal, I would ask that you keep your audio on but your video off. But Mr. Caldwell, we heard what you were saying and the commission reviewed your motion. Mr. Cleaver, would you like an opportunity to speak?
Yes, I'll try to keep it brief, Your Honor. Thank you. OPC's reasons for opposing the motion for leave are set forth in the written motion that we filed. I won't repeat them now in the interest of efficiency. I would simply add, Your Honor, after listening to Mr. Dodge, I didn't hear anything about what changed since July 16th. The company didn't ask for reconsideration of the commission's procedural schedule, did not file any response with the commission raising a concern or requesting rebuttal. It was a tight turnaround, but it was extended to some degree based on Washington Gas's motion. And again, in that motion, there was no reference to a need for a round of rebuttal testimony. Procedural schedules are obviously important in matters before the commission. They determine how the parties allocate the resources to deal with all the various dockets that we're all involved in. And they determine, how we plan our schedules. And to file a written testimony a month and a half after the procedural schedule comes out without a peep from the company about the need to do so during the typical time to file something, the Friday afternoon filing, when you want it to kind of go under the radar, just 4 days before the hearing is to begin, is not appropriate. And for that reason, we would ask that the commission deny the motion for leave to file rebuttal testimony.
Mr. Dean, I recognize that staff counsel supports OPC. Do you have additional commentary?
No, Your Honor. Assuming that Washington Gas does have the burden of proof, we supported the Office of People's Counsel's filing.
Thank you. The commission in July extended the procedural schedule by an additional 30 days to accommodate concerns that Washington Gas Light raised in its request to delay the procedural schedule. That additional 30 days was not intended to prolong the briefing schedule and to provide for rebuttal testimony. I think it was incumbent on WGL to communicate with counsel for the three parties regarding their desire and wish to file this testimony and not to surprise them on the Friday afternoon before the weekend, the week before the trial is set to begin. That said, WGL does bear the burden in this case and has the opportunity to provide the last round of testimony in this matter. After reviewing the testimony of witnesses Murphy and Reed on rebuttal, I believe that the commission could afford the weight appropriate to that testimony, which largely focuses on this dispute regarding whether or not a commitment was made. So I am going to permit the rebuttal testimony to be introduced by counsel for WGL. But there is a price to be paid for this testimony, furthering our administrative efficiency. Number one, I'm not going to allow any Reed and Murphy. Number two, I explained my rules of conduct just a few moments ago. I will allow, for the sake of due process, the other three parties to engage in some discovery-like questioning of those witnesses. This is not going to be an open-ended fishing expedition, but will allow the parties an opportunity to ask additional questions of these two witnesses. Let me just ask the three parties, AOBA, OPC, and staff, if they took advantage of any discovery in the short window between the rebuttal testimony was filed and today. Mr. Caldwell?
AOB, Your Honor, we did not.
Mr. Dean, if you could, thank you. Mr. Caldwell, we had some background noise. Just to be clear, you did not seek any discovery.
That is correct, Your Honor. I was preparing for today's hearing.
I suspect you were preparing for your cross and you were thrown a curveball today. Mr. Cleaver.
No, Your Honor. OPC did not serve any discovery after Friday's filing. Of course, the governing turnaround period right now in the case is 5 business days. And again, we were also preparing for hearing.
You raise a good point regarding the turnaround. And Mr. Dean?
That would also be true of staff with the 5-day turnaround period. We realized that there was no opportunity to respond, and especially given that the rebuttal testimony was filed just before the end of the day on Friday.
Okay, thank you, Mr. Dean. All right, so my ruling is the rebuttal testimony of witnesses Reed and Murphy come in. WGL does not have an opportunity to ask live rejoinder of those two witnesses, and the parties may seek limited discovery through those witnesses on cross-examination. Are there any additional preliminary matters before we begin? All right, I will provide the parties with the opportunity to make a brief opening statement. It's a voluntary opportunity. You may also reserve your statement until the point in time where you make your case in chief. I'll see if any party wishes to, before turning to WGL. Mr. Caldwell, do you wish to make an opening statement?
Not at this time, Your Honor.
Okay, you could reserve if you'd like. Mr. Cleaver?
Would prefer to reserve, Your Honor. Thank you.
Mr. Dean?
Staff also not at this time.
Thank you. I'll turn it over to counsel for WGL if you wish to make an opening statement or if you wish to call your first witness.
I do wish to make an opening statement. Let me apologize. I'm at the office for the first time in many months, and we have very powerful energy efficiency measures, including light switches that go off if it doesn't sense that I'm moving around. So if I go dark, give me a moment and I'll run over and wave my hand in front of the light switch as I just did. Good morning again, Mr. Chairman and Commissioners. My name is John Dodge, and I'm here to represent WGL in this matter. I would greatly prefer to be appearing before you this morning in person, but I am grateful that we have the technology to join together safely today and tomorrow. As so often happens in cases before the Commission, and as usually should happen, the issues in this case have been distilled into just a few key questions. The most important question you have been asked to decide is whether, in a settlement document executed nearly 20 years ago, the following sentence constitutes an enforceable commitment. And I quote, "The company intends to complete the changeout." The changeout reference pertains to removal of mercury regulators. The company believes that simple sentence, which does not include the word commitment, does not create a commitment. We offer 3 witnesses, including an expert witness, to support our interpretation. Staff, OPC, and AOBA disagree. Their positions, to borrow the apt phrase of my colleague Mr. Buckley, rely on regulatory alchemy. They transmute the word intends into the word commits. They read into a simple sentence a word and a meaning that simply do not exist in the plain language of that sentence. In the same settlement, indeed in the very same paragraph, the company did commit to filing annual reports regarding its changeout program. In contrast to its expressed intention to complete the changeout, the sentence describing the annual filing requirement actually includes the word commits. As a result, and is noted in the company's rejoinder comments in this proceeding, Washington Gas has acknowledged that it should have filed 3 required annual reports, and the company calculated and agreed to pay a civil penalty associated with those oversights. Staff, OPC, and AOBA also failed to establish any rate-making harm to the company's Maryland ratepayers resulting from the company's necessary departure from its 2002 intention to change out mercury regulators. That's because there was no such harm. The parties won't tell you that Washington Gas changed out 74% of the estimated number of mercury regulators in Maryland during the 10 years following 2002. They won't tell you that Washington Gas spent less on that changeout activity than if the cost of service adjustment for mercury regulator replacements approved in case number 8920 had been carried forward for 10 years. They won't tell you that Washington Gas has removed more than 90% of the original estimated number of mercury regulators through today's date. But Washington Gas is not resting on those data. The company has notified the Commission that we will remove all remaining mercury regulators in Maryland. We will soon begin a 1-year survey to locate all remaining regulators. Mercury regulators located in multifamily locations will be removed over a 3-year period. Mercury regulators located at single-family homes and other locations will be removed over a 5-year period. We commit to keeping the Commission abreast of our progress, including the impacts of COVID-19 or other challenges that may arise. Finally, Your Honors, the evidence in this case shows that Washington Gas exercised due care as required by law in its management of mercury regulators. There is no evidence of any pipeline safety violation, and the parties' calls for civil penalties are not supported by the Public Utilities Article or Commission precedent. We look forward to presenting our case to you this morning, which answers all the outstanding issues posed in Order Number 89550. We also look forward to answering your questions. Thank you.
Thank you, Mr. Dodge. You have 4 witnesses for us today, is that right?
We do, Your Honor, and I will first call John J. Reed to the stand. I have for the commission, a fairly lengthy voir dire to qualify Mr. Reed as an expert. I'm happy to embark on that voir dire, but if the commission is willing to accept his bona fides, his 40 years of experience and hundreds of regulatory appearances, I think we can probably dispense with most of my questions.
Thank you, Mr. Dodge. I know that Mr. Reed's CV was attached as an exhibit to a very lengthy exhibit to our testimony. Let me ask the parties if there's any opposition to qualifying Mr. Reed as an expert witness for the purposes of avoiding voir. Mr. Caldwell.
AOPA has no opposition, Your Honor.
Mr. Cleaver.
Yes, Your Honor. Mr. Reed has already been qualified by this commission in the case 9449, the 2018 or 2017 to start rather, case concerning AltaGas's acquisition of Washington Gas, and OPC's position is that it's not necessary to conduct voir dire.
Thank you, Mr. Dean.
Oops. Staff does not object.
Okay. Thank you. Mr. Dodge, we could skip the voir dire because of Mr. Reed's background and previous qualifications as an expert. He will be provided an opportunity to provide his opinion in this matter.
Thank you, Mr. Chairman. At this time, Washington Gas does call John J. Reed to the stand.
Thank you, Mr. Reed. Can you just please raise your right hand? You'll be sworn in. Madam Court Reporter, can you swear the witness?
I must be muted. Can you hear me now?
We can.
Okay, thank you. Sir, do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I do. Thank you.
Thank you. Mr. Dodge, your witness.
Thank you, Mr. Chairman. Good morning, Mr. Reed. Can you hear me okay?
I can. Good morning.
Thank you. Did you cause to be filed in this case direct testimony dated August 7th, 2020?
Yes, I did.
Am I correct? And did you also cause to be filed corrected confidential direct testimony on August 10th, 2020?
Yes, I did.
Am I correct that your direct testimony consists of 20 pages of narrative questions and answers?
That's correct.
Do you have any corrections to your direct testimony at this time?
No, I do not.
If I ask you the questions in your direct testimony, would your answers today be the same?
Yes, they would.
Am I correct, Mr. Reed, that you also caused to be filed in this matter rebuttal testimony dated September 18th, 2020?
That's correct.
Am I correct, sir, that your rebuttal testimony consists of 11 pages of narrative questions and answers?
That is correct.
And your rebuttal testimony also includes one attachment. Is that correct?
That is correct.
Do you have any corrections to your rebuttal testimony or its attachment at this time?
No, I do not.
If I ask you the questions in your rebuttal testimony, would your answers be the same?
Yes, they would.
Do you adopt the pre-filed direct and rebuttal testimonies in this matter as your sworn testimony?
Yes, I do.
Your Honor, Mr. Reed is available for cross-examination. I would say before I turn him over, I look to the chairman for whether we should move for admission of his testimonies now or wait till after cross-examination.
We could move them in now unless there's any objection. What are we marking them as?
I believe that Washington Gas 1 is the public direct testimony of John J. Reed. WGL 1C is the confidential version of Mr. Reed's direct. And WGL 2 is the rebuttal testimony of John J. Reed. And I would so move for their admission.
Those exhibits are so marked and entered into evidence.
Thank you,
We'll begin
Your Honor.
with,
Mr. Reed is available.
Thank you. We'll begin with cross-examination by Mr. Caldwell.
Thank you, Your Honor. Good morning, Mr. Reed.
Good morning.
Can you hear me okay?
I certainly can. Go ahead, sir.
Thank you. Your testimony generally addresses the relationship between rate-making principles and utility decisions on how to spend revenues. Would that be a fair assessment?
Yes, it does cover that topic.
Yes. Thank you. Under general rate-making principles, does financial
I'm sorry, you broke up, sir. Could I have that question again?
Sure. And I apologize. I guess it's my cut rate system here. Under general rate making principles, does the financial inability or problems, hardship with the financial hardship is a better word of the utility, excuse a commitment to make system repairs?
No, if by commitment to make system repairs, you mean commitment to maintain safe, efficient, and reliable service. No, I don't think financial hardship excuses the utility from performing to that standard.
What about improvements?
Same question. Any improvements necessary to meet its public service obligations, in my opinion, are not excused by financial hardship.
Testimony, you discussed the dedication or earmarking of utility funds. I believe that would be lines 19 through 25.
That's page 4 of the direct.
Yes, I'm sorry, page 4 of the direct.
Yes, I have that page.
Okay. Is it your testimony that only utility commitments or tasks with dedicated or earmarked funding must be completed by the utility?
No, there are clearly obligations that utilities have that don't involve earmarks, and some of those are in fact discussed in my rebuttal evidence. So no, the limitation is not that you have to earmark funds or have a tracker. There are clearly obligations that they go beyond that as well.
Just a few more questions. On page 10 of your testimony, 6 through 23, no obligation or commitment is created by commission approval of specific costs. Do you see that?
I'm sorry, again, could you repeat the question?
Sure. At that page, page 10, lines 6 through 23, I believe you should suggest that under traditional rate-making principles, no obligation or commitment is created by commission approval of specific costs. Is that correct?
Outside of, again, specific tracked programs or similar types of regulatory mechanisms, that's correct. The inclusion of a cost in the revenue requirement does not create an obligation to spend funds collected from the approved rates based upon the way in which the revenue requirement was developed.
Your task or however you'd like to describe it would be completed?
Mr. Caldwell,
Yes, sir.
I'm gonna have to stop you there. We can't hear what you're saying. Can you try turning off your camera? Perhaps that might free up some bandwidth. You could re-ask the question.
Okay. Are you with me, Mr. Reed?
Yes, sir. Go ahead.
Okay. I'll just start over. I apologize, Your Honor. At page 10, you suggest that under traditional rate-making principles, no obligation or commitment is created by commission approval of specific costs. Is that correct? Is that a fair assessment?
That's correct. Apart from, again, the specific tracked programs that do establish recovery as a function of a specific expenditure.
Okay. I'm sorry. We're finished. I didn't mean to cut you off.
No, I was finished.
Okay. But isn't there an expectation that the undertaking will be completed?
Could you be more specific by your phrase, the undertaking there?
Well, I'm hesitant to use the word commitment because that's verboten in Washington Gas's testimony. But if the company agrees to do something and it's not tracked, there's no earmark for that particular task. Isn't there still an expectation that if rate relief or rate recognition is accorded the company, isn't there an expectation that that particular task or duty will be completed?
Your Honor, I will allow the witness to answer, but I'm going to object to the form of the question, which I think mischaracterizes the witness's testimony.
Go ahead. If I should proceed. No, I don't think, again, the inclusion of an element of revenue requirement in the rates that are approved creates an obligation to spend those funds on that item. And the examples I used in my evidence are there are revenue requirement entries, and there are, in fact, pro forma entries in WGL's past rate cases for postage, for paving expense, for many other individual components. But I would find it hard to imagine that someone would seek to come before this commission and say the company didn't spend what it said it was going to spend on postage expense because, in fact, it switched to electronic billing, or it didn't spend as much, it spent more perhaps on paving than it had in rates. Again, the revenue requirement is used to develop rates. Rates are what's approved. Rates are what's placed into the tariff. And obviously, the company has to operate according to its obligations under the tariff, as well as its obligations under statute. So yes, the continued operation of the distribution system on a safe, reliable, and efficient manner is an obligation that transcends the development of the revenue requirement. But no, I don't think approval of an item in the revenue requirement either creates an obligation or even an expectation that the funds derived from the approved rates will necessarily be spent on those items.
So it's your testimony that when Washington Gas received rate recognition for the replacement of mercury regulators, there was no expectation that that particular task, that particular plan would be undertaken?
As I understand your question, I think there was an expectation, and I think there was a plan, and there was an intent. But again, all of those are subject to change and reflect management discretion as to how to operate the company in a manner to satisfy its public service obligation. But I do agree that there was a plan, there was an intent that was expressed in the settlement. But I don't find the decision to pivot to different spending priorities in 2004 and 2005 represents somehow an abandonment of a commitment or an obligation or even a requirement that the utilities spend the funds in a specific manner.
Well, and thank you. I wasn't suggesting that. The distinction I'm trying to draw is between an obligation and an expectation. I think your testimony, Washington Gas, is clear that the company felt it did not have an obligation to undertake these to complete the plan. Okay, my specific question is, but wasn't there an expectation, both on the part of the company and the part of the other parties, as well as the commission, that when they granted rate recognition of this plan to complete this plan, that there was an expectation that the plan would be completed?
Your Honor, I'm going to lodge another objection. I believe the question calls for speculation, particularly as regards other parties in prior cases.
If I might be heard.
Hold on.
I'm sorry.
Hold on. Objection is noted. The witness may answer the question. Was there an expectation?
My view is the company expected, I can certainly speak based upon what I've read, is my understanding that the company's expectation was it was going to undertake the program, but just like an expectation that interest rates were going to be 4% when it next refinanced debt, things change. So we need to carefully distinguish between expectation and commitment or obligation.
Thank you. Just one question on your rebuttal testimony, and that's on page 10, lines 16 through 18.
Yes, I'm there.
You there? There, I'm trying to summarize, correct me if I'm wrong. You conclude that there was a breach of obligation by the company in failing to file annual reports.
That's correct.
But again, it's your testimony that there was no breach of obligation to complete the plan as presented by.
Could I have the second part of that question again?
Well, the first part is that you've concluded in your rebuttal testimony that Washington Gas breached an obligation to file annual reports. Is that correct?
Yes.
But you also conclude in your testimony, both direct and rebuttal, that there was no breach of an obligation to complete the regulator replacement program as explained in prior testimony in case number 8920 and case 8959.
That's correct. I think that expectation or plan does not rise to the same level of commitment that we have for the reporting commitment, which is clearly laid out as being a commitment. So yes, I do distinguish between those two.
Okay, thank you. Your Honor, I'd ask for a little guidance at this, which were pre-filed by AOBA, the witnesses in case number 8920 and 8959. I would like to get those into the record. I don't know if that's something we can stipulate to, or if I need to lay a foundation with Mr. Reed to get them entered into the record.
Let's see. You said this testimony is in case number 8929. Which case is that?
Sorry, it's 8920 and 8959.
Okay, 8920 is the 2002 base rate case. 8959, which case is that?
That's the subsequent case, subsequent rate case, where the testimony, there's testimony from Mr. O'Flynn and Mr. Rana, if I'm pronouncing his name correctly, on the replacement plan.
Is there any objection from the utility to include this testimony as an exhibit?
No objection, Your Honor. In fact, I think other parties may have had it on their preliminary list as well.
I saw that as well. We have an extensive list of prior testimony in these rate cases going back to 2002. Mr. Colwell, I believe this testimony will be introduced by others, but if you'd like to mark it as an AOBA exhibit, you may.
Whichever the commission's preference would be, I thought, and we had discussed this briefly yesterday, is that maybe the testimony could come in as a commission exhibit. That way it resolves any confusion with respect to briefing. I'm happy to mark it as AOBA 1 through 4.
Well, Mr. Colwell, how about this? I can't guarantee that commission staff is going to introduce it as an exhibit, but I suspect they will. If they don't, you could mark your exhibit at that time.
Okay. Thank you, Your Honor. That concludes my examination. Thank you, Mr. Reed.
Thank you.
We'll turn to Mr. Cleaver.
Thank you, Your Honor. Good morning, Mr. Reed.
Good morning.
Let me ask you, before I begin, as I was preparing, before I get into the substance of your testimony, as I was preparing my outline, I noticed again, and I remembered that you refer to your testimony that you filed in this docket 9622 not as testimony, but rather you call it evidence. Are you aware of that?
Yes.
Right. And you would agree that testimony is one type of evidence, correct?
Correct.
Okay. And you would also agree that the common term used to describe when a witness writes down a question and answer testimony in a format of question and answer and gives their opinions, that it's referred to at the commission as testimony, correct?
Where it's written typically as pre-filed testimony, yes.
Yeah, let me ask you, why are you using a more general and less specific term of evidence as opposed to the more specific term of testimony to describe what you filed in this case?
I don't think that was meant to be a distinction.
Okay. I went back and took a quick look at your testimony from 9449, and in that case, you, as all other witnesses do, you referred to it as testimony. Is this just a stylistic change that you've decided to go with in the last, since 9449?
I'm not sure it's a matter of style. It probably is a matter of template that we used within our shop. But again, the wording is not meant to create a distinction.
Okay, thank you. Mr. Reed, from reading your testimony in this case, it's safe to conclude that you disagree that there was a commitment flowing from either the 2002 rate case 8920 or the 2003 rate case 8959 on the part of the company to replace all inside mercury service regulators in Maryland. Is that fair to say?
Yes, I think the commitment to replace the MSRs within the 10-year time frame that was expected does not rise to what I would call a commitment. There was a related commitment with regard to reporting. So we just have to distinguish between the actual replacement and the timing or pace of that replacement and the issue of reporting.
Thank you. And I assume you've reviewed all the orders that the Maryland Commission has issued in this docket in 9622. Is that fair to say?
Yes, I have.
Okay. And so you're familiar that the order to show cause issued on September 5th, 2019 indicates the Commission's conclusion that there was a commitment to replace indoor mercury service regulators flowing from those cases. Are you aware of that? And if you want me to walk through them, I can, and I'll try to be quick, but tell me if you want me to pull up the order and refer you to a specific place.
Well, let me answer as best I can, and you can make that choice. My understanding of the issues set for hearing in this case included issue 1, which was whether WGL has met its stated commitments in cases 8920 and 8959. As well as whether the funds collected from ratepayers expressly for this purpose were so used. So given that those were issues set for hearing, that's why my evidence or testimony, to use your phrase, speaks to those 2 points. I think the issue of whether WGL met its stated commitments is an issue that the Commission wanted to take evidence and testimony on, which is why it's on the issues list for this hearing.
Okay, let me do it this way. If I could refer you to what's been marked for convenience as OPC Exhibit 18, which is the show cause order issued in this docket. The order number is 89248, September 5th, 2019.
I have that document.
Okay. If you could turn to page 3, and the first full paragraph that begins about 5 lines down that starts with the word subsequent. Tell me when you're there.
I see that.
Yes, and you see it says subsequent to the issuance of the report, the Commission found that in 2003, WGL committed to replace all 66,793 mercury service regulators located inside customers' premises over 10 years. So if I understand your testimony correctly, you dispute the Commission's, to use the Commission's word, finding that in 2003, Washington Gas made a commitment to replace all indoor mercury service regulators.
The citation, which you did not mention for that sentence, footnote 7, goes to the direct testimony of Hadrip Rana for Washington Gas Light, which I did review with regard to what was the nature of the commitment made. I do not believe that the testimony of Mr. Rana created a commitment to spend the funds within a specific time frame and to achieve a specific result within that time frame. So I'm cognizant of the commission's language in this order, in order 89248. And I'm also cognizant of the source they cited for that statement.
Thank you for that. The question is, isn't it correct that you disagree with the commission's conclusion, the commission's finding, to use the commission's word, that a commitment was made to replace all indoor mercury service regulators in that 2003 case where Mr. Rana filed his testimony?
If the commission has already concluded that that was an enforceable commitment, then yes, I do disagree with that. I think the commitment is of a different nature, as I've made clear in my evidence. And again, I would suggest the commission's hearing order here indicates that it is seeking and taking testimony on that point.
Thank you. Let me refer you to what's been marked as OPC Exhibit 19, which is the April 29th, 2020 notice of evidentiary hearing in this docket, 9622. The order number is 89550. And I believe that you yourself just referred to this a moment ago. So tell me when you're there. And specifically, I'd like to ask you about something on page 6. Tell me when you're there. Paragraph 13 specifically.
Yes, I'm there.
Okay. Now, as I just mentioned a moment ago, and as you can see, this notice of evidentiary hearing was issued in April of 2020. Correct?
That's correct.
Okay. Now, before this notice of evidentiary hearing was issued, Washington Gas had filed a response to the show cause order back in October of 2019, correct?
I believe that date is correct, yes.
Yeah. And Washington Gas also filed rejoinder comments responding to the responses to Washington Gas's show cause response on March 2nd, 2020. Is that correct?
It did file a rejoinder. I'll take that date subject to check, yes.
Fair enough, thank you. And in both of those filings with the commission, Washington Gas set forth its reasons for disagreeing that a commitment had been made in either case 8920 or 8959. Are you familiar with that?
I think you need to be more specific. A commitment to do what?
Fair enough. In its October 18th, 2009 response to show cause and in its March 2nd, 2020 rejoinder comments, in both of those filings with the commission, Washington Gas disputed that it had made a commitment in either case 8920 from 2002 or 8959 from 2003 to replace all indoor mercury service regulators in Maryland on a 10-year time frame. Correct?
I believe that's correct.
And so when the commission, now I'd like to refer you to paragraph 13 on page 6 of the April 29th, 2020 notice of evidentiary hearing. And here in paragraph 13, the commission says, the commission has reviewed the filings and positions of the parties and concluded that an evidentiary hearing is required to resolve the following outstanding issues. 1, whether WGL met its stated commitments in case numbers 8920 and 8959 to replace all mercury regulators located within its Maryland service territory over a 10-year period. So you would agree that when the commission made this statement here that I just read, it had seen and was familiar with Washington Gas's arguments as to why, according to Washington Gas, there was no commitment to replace mercury service regulators over a 10-year time frame. Right?
Certainly, I agree that when the commission wrote this in April 29th of 2020, that it had reviewed the filings and positions of the parties that had been submitted prior to that date.
Okay, thank you. And I'll wrap this up soon, but let me ask you about one more. What's been marked as OPC Exhibit 20, and that is the order denying the Office of People's Counsel's motion for reconsideration. That order number is 89577, and it was issued on July 15th, 2020. Tell me when you're there.
I may not have that one printed out, but go ahead. I may be able to pull it up.
Okay. Do you want me to give you a minute to look for it?
What was the order number?
The order number is 89577, and the date is July 15th, 2020, and it's in this docket 9622.
Yes, I have that. Which page?
Page 1, paragraph 1.
Okay, I'm there.
And in that paragraph, the commission again states that it reiterates its conclusion that the only issues requiring an evidentiary hearing and the possibility of sanctions involve the extent to which Washington Gas Light Company complied with its 2003 commitment to replace all existing mercury service regulators over a period of 10 years. You see that?
I see that, yes.
Okay. And again, you disagree with the commission's conclusion stated there again that there was a 2003 commitment to replace all existing mercury service regulators over a period of 10 years.
In terms of an enforceable commitment to do it at that pace over that period of time, yes. Again, I think it's the citation that the commission used for that statement earlier. I think it's quite clear that this was an intent, a plan of the company, no question about it, and that it had a commitment to reporting. So, in my view, the nature of those commitments that the company made, and even the plans and intentions that the company had, are relevant. But of course, that will be up to the commission to determine.
Okay, thank you. And just one more question on this document, this order from July 15th. There was one commissioner dissented on the ultimate issue, which I'm not going to ask you about, but I would like you to turn to page 3 of the dissent, which is labeled D as in dog 3. And specifically paragraph 6.
Give me just a moment to get there. I'm there. Go ahead.
Okay, and you can see here that the author of the dissent also, again, reiterates the conclusion the commission made, the finding, to use the commission's original term, that in 2003, WGL committed to the commission that it would replace all MSRs located inside customers' premises over 10 years. You see that?
I do.
Okay, thank you. Mr. Reed, if I could refer you to what's been pre-marked by Washington Gas as WGL Exhibit A as an apple, which is an August 16th, 2019 letter from Stephen Price of Washington Gas to John Clemenson of the Maryland Public Service Commission. Tell me when you have that available.
I'm not sure that I have that here on my system. Can you give me a broader description of the document?
I can tell you something else that may make it easier to find. It's also attachment 6 to Washington Gas's response to the show cause order filed on October 18th, 2019.
Okay, give me just a moment. I'm sorry, I have that response to the show cause order. I don't think I have attachment. You said 6?
That's correct.
I think we're going to have to proceed subject to check here. Why don't you just read me the portion that you want to refer to?
Actually, for this document in particular, my question concerns the entirety of the document. So, Your Honor, this was a document listed on Washington Gas's exhibit list. I'd be happy to email a copy to counsel now. I'm sure counsel has the document that I'm talking about. Maybe he could send it to his witness via email.
Well, yeah, it is the first pre-marked exhibit A. It has a mail log number. If Mr. Reed could perhaps pull it up on our system, it's mail log number 227198. That might be the fastest way.
Okay.
Grant,
And
you
I'm
want to
sorry,
read the log number again?
Mail log number 227198. I'm actually currently trying to download it from the PSC website now. It's taking a little while.
227198. I see that there, but okay, so it's item 8 in the docket.
There should only one mail log number. The document is large. It's 398 pages, so it may take a moment to download. Were you doing a mail log search, Mr. Reed?
No, I was doing a docket search.
Yeah, no, it'd be faster if you did a mail log search from our website.
I do think it's downloading. It does appear to be many megabytes.
Right. All right, you found it. Just give it a moment. Mr. Cleaver, when the witness downloads the document, you are pointing us in the direction of attachment 6. Is that right?
Yes, that's correct, Your Honor.
Okay, which is page 116.
Thank you, Your Honor.
Okay, I think I'm just about there. I have that. Go ahead.
Okay, thank you. So, Mr. Reed, just to say it again, because just a little bit of time passed. This is an August 16th, 2019 letter on Washington Gas letterhead from Stephen Price, the Assistant Vice President of Safety, Quality, and System Protection for Washington Gas, to John Clemenson, the Deputy Chief Engineer of the Maryland Public Service Commission. Do you see that?
I do.
Okay. And let me ask you, have you seen this letter before?
Yes, if it was attached to the response to the show cause order.
Okay. Are you aware that the word commit or commitment doesn't appear anywhere in this letter?
I haven't searched for that, but that does not surprise me.
Okay. Would you accept that subject to check?
Let me do a quick review. I don't see the word commit or commitment there.
Right. And I note in the first sentence here, the author writes that he's writing to communicate our proposed plans in response to the recommendations following the NTSB's investigation of the accident in Silver Spring, Maryland, back in August 2016. Do you see that?
I do.
So let me ask you a question. Just trying to drill down to the bottom of your understanding of what's a commitment and what isn't. Are there any commitments in this letter?
I think, again, this is a proposed plan, which, as I recall, what the commission asked for in the show cause order. I think it could be certainly transformed into a commitment at the conclusion of this case.
Okay, but your testimony is that when this letter was provided to Mr. Clemenson of the commission, that nothing in this letter as of August, forgive me, as of the day of the letter, August 16th, 2019, no commitment was made at that time. Is that your testimony?
I think that's correct. It's conveying the plan, which is, again, from operating from memory, what the commission asked for in the show cause order. And I think that plan appropriately is subject to review by the commission and in this docket.
There are many things mentioned in this letter, and it's lengthy, so I'm not going to go through the whole thing. I know we don't have unlimited time. Let me ask you just about, I'll take a random thing in here. Hold on, bear with me 1 second. Let me ask you about something that appears, just to carry that point a bit further. If you could turn to page 2 of the letter.
I have that.
In the middle of the page, like at the end of the discussion of what would be recommendation 1, there's a paragraph that begins with the 3 words "beyond the changes." Do you see that?
I do.
Okay. So Washington Gas says here, beyond the changes in Washington Gas's work management system and O&M manual, we're implementing performance goals for supervisors to audit a subset of completed work orders for completeness and accuracy. I'm going to ask you a hypothetical question, which I know you're used to getting because you're an expert witness. If after this letter had been sent to Mr. Clemenson, the supervisors in question here had just, again, hypothetical, certainly not suggesting this happened, but if the supervisors here had balked at this implementing these performance goals and this auditing process, and management had said, the supervisors are right, we actually, that's just too burdensome and too much bureaucracy for these supervisors to deal with. Again, speaking hypothetically, would the company have been required to inform the commission of that?
You indicated that supervisors were balking and that the company agreed that the procedures that they were being asked to follow were too burdensome. I'm not sure you took it to what the company's resolution of that was. So in terms of whether there's a duty to report, I think it would depend on the resolution there.
Well, let's assume that the company determined that this entire regime of performance standards and auditing was not necessary. What would the company then have had some obligation to inform the commission of that change in plan, or to seek some approval to deviate from the plan that had been presented to Mr. Clemenson?
Your Honor, I'm going to object. I gave Mr. Cleaver a bit of latitude because he posed it in hypothetical. Now, apparently, we were out of the hypothetical, and I think beyond the scope of the direct or the rebuttal testimony of the witness.
Your Honor, the witness's entire testimony is about what constitutes a commitment before a regulatory body. And I'm just trying to take that to the end. I can promise the commission that this line of questioning is wrapping up quickly. And just to be clear, the question is still hypothetical. Mr. Reed asked me for clarification on my hypothetical. To the extent it wasn't clear from my question, I just would clarify that these questions about this performance standards and auditing program and just understanding Mr. Reed's opinion are all hypothetical.
Mr. Cleaver, I see where you're trying to go. It's in perhaps a bit of a clumsy manner with this, using this as an example. Let's be a little more direct.
Sure.
I'll ask a question if you'd like to rephrase.
I think I've made the point, Your Honor. I'll move on. Thank you.
Thank you.
Mr. Reed, in his opening statement today, Mr. Dodge highlighted the fact that nowhere in the order from 8920 was there the word commit or commitment with respect to anything other than the reporting requirement. Is it your view, is it your expert opinion in this case that absent that specific word, that there can never be a commitment based on a representation that a utility makes to a regulatory body?
No, as I've said, I think there are commitments, first of all, established by statute in terms of public service obligations. In my view, those are commitments when you accept your, excuse me, your franchise, your certificate to operate as a public utility. So no, I don't think that commitments are limited to statements made in a rate case or even in a merger case, as I've indicated in my rebuttal evidence, my rebuttal testimony. But so I think that answers the question. I think commitments can come from many sources. But I do recall a statement that Mr. Dodge made in the opening statement, yes.
Is it significant to your assessment of whether or not there was a commitment in this case that the language in the settlement agreement uses the words intend and plan? Does that feed into your ultimate opinion about whether or not there was a commitment to replace the regulators in this case?
Yes, it does factor into my opinion. And I think your question is probably limited to plan and intend with regard to the MSRPP and the 10-year time frame. So yes, that does factor into my opinion.
Okay, let me refer you to what's been marked as OPC Exhibit 2. And this is the rebuttal testimony of Frederick Klein on behalf of Washington Gas in case number 8920.
You give me just a minute to try and pull that up. I have that.
And if I could refer you to page 33 of that testimony, and it is also based on the OPC exhibit, page 33 of the PDF.
Okay, I'm there.
And you can see down here on line 17, there's a heading that says Adjustment 24 Mercury Regulator Changeout. You see that?
The testimony of witness Klein, page 33.
Page 33, line 17.
That's not where it appears in my copy. Hang on one second, please.
This is actually, if I said direct testimony, I misspoke and I apologize. What was marked as OPC Exhibit 2 is Mr. Klein's rebuttal testimony in case number 8920,
Okay.
page 33.
I have the adjustment 24 on page 53 of the direct. So this may take a minute. I'm sorry, I don't think I have Mr. Klein's rebuttal in front of me. This may be something I have to pull up.
Yeah, sure. Let me know when you're there.
Your Honor, with your permission, I will email it to the witness.
Okay.
I would appreciate that. Thank you.
I just hit send.
Well, I'll give it 1 minute to get down here. Okay, thank you. I have that now. And you said page 33.
That's correct.
And I am there with regard to adjustment 24.
Right. And Mr. Klein here, and he was the cost of service witness for Washington Gas in case 8920, the 2002 rate case, correct?
Yes, that's my recollection.
Right. And have you reviewed this testimony before?
Yes.
Okay. And it's here where he's discussing adjustment 24, beginning on line 17. He's asked to summarize his adjustment 24 mercury regulators. He states that it reflects the capital costs and maintenance costs associated with the mercury regulator changeout program presented by company witness Cook in his direct testimony. Then he says, as described by company witness Cook, Washington Gas will replace over 66,000 mercury regulators in the Maryland jurisdiction over a 10-year period. Is it your testimony that that too does not constitute a commitment, that statement?
That is my testimony. That was the company's intent. Again, even the number of mercury regulators in Maryland were not known with certainty. So again, it reflects, in my view, the company's intent, the company's plan, but not a commitment, as I use that term in terms of an enforceable item that would subject the company to penalties if it did not achieve that pace or that number.
All right, so the fact that Mr. Klein here doesn't use the term intent or plan, that doesn't, and he says actually will, that doesn't change your opinion?
No, and I don't find that to be a level of specificity that's different than any other projection that's contained in the revenue requirement.
Okay, thank you. Let me refer you to what's been pre-marked as OPC Exhibit 4, which is a transcript of the August 1st, 2002 hearing on the stipulation and settlement in case number 8920. Do you have a copy of OPC Exhibit 4?
Again, that's going to take me just a moment.
Again, Your Honor, I'm happy to email it to the witness with your permission.
That will speed things up if you could.
Please do, Mr. Dodge. Mr. Cleaver, if there are additional OPC exhibits, perhaps Mr. Dodge could send them at the same time.
Your Honor, I know this is a challenging process still for everyone. I just would note that all these exhibits were provided timely to Ms. Howard pursuant to the scheduling order, and then the updated one, a few additional ones were provided.
Now, you are exactly right. Everybody should have your exhibits before them at this time.
But I'm happy to do, of course, whatever the commission would like me to do now in terms of, I think for Mr. Reed.
Well, I'm asking you, are there any other exhibits you plan to cross Mr. Reed on that we could just send to him now, aside from Exhibit 4?
No, I believe this is the last exhibit I have. That I plan to ask Mr. Reed about, the last OPC exhibit, or any party's exhibit.
Mr. Reed, have you received the exhibit?
I have, and it's open. Which page would you like me to go to?
Could you go to what's on, this is a 101-page PDF. So I would ask you to go to page 49 of the PDF, which is, with respect to the transcript pages, there's more than one transcript page per PDF page. The transcript page is the bottom of 263, but you'll see that if you go to page 49 of the PDF.
Okay, I'm there.
Okay. This document is as I mentioned, a transcript of the hearing before the commission on the stipulation and settlement in case number 8920. And the hearing was held on August 1st, 2002. Have you seen the transcript before?
Yes.
Okay. This hearing was before two commissioners, Commissioner Curran and Commissioner Guns, as well as a third member of the panel who was the chief hearing examiner at the time, Andrew Mosier. Are you familiar with that?
Yes.
Okay. And I'm going to ask you some questions about an exchange between hearing examiner Mosier and Adrian Chapman. You're familiar with Adrian Chapman, correct?
I am.
And at the time of this testimony, he was, I believe, the vice president of regulatory affairs at the company. Are you aware of that?
I can accept that subject to check.
Okay, thank you. If you look here at the bottom of page 263, you can see that hearing examiner Mosier asks Mr. Chapman about paragraph 10 of the original stipulation, which of course became paragraph 11, but he's asking him about paragraph 10, which concerns the mercury regulator replacement program. Do you see that?
I do.
Okay. And specifically, hearing examiner Mosier asks Mr. Chapman, he says, I'm going to start on line 2 of page 264. He says the paragraph states that the current plan is to complete the mercury regulated changeout program as set out in witness Cook's testimony. And the hearing examiner continues and says, that implies to me that there could be a change. And I'm wondering if that's the case and how the settling parties would be brought into this. And at first, Mr. Chapman says, I'm not sure if I understand the word change. Witness Cook, I think, identified a 10-year program to completely replace where there are mercury regulators in our service area. And then the hearing examiner continues and says, and my take on the settlement is that that is what the settling parties are signing on to. It's just that terminology there. And I think it's reasonable to conclude that when he says that terminology there, he's referring back to this phrase, quote, current plan. Would you agree with that?
I do.
Okay. And he says, I'm wondering, is there the potential for a change there? And I guess if there is it something that's unilateral? And would you agree with me that he means something the company can do on its own when he says unilateral there? Do you agree with that?
I do.
He says, or would that be brought back to at least the 3 settling parties? Do you see that?
I do.
Okay, and then continuing on to 265, and we're almost at the end of this exchange. Mr. Chapman says, I don't think the parties, apologize, PDF. I don't think the parties, and I'm now on PDF page 50, I don't think the parties or the company intends for there to be a change in how the company implements witness Cook's as filed proposed 10-year changeout. And then the hearing examiner concludes by saying, so then we can conclude that the changeout program that will be implemented is outlined in witness Cook's testimony. And Mr. Chapman says, yes, that's how it has been discussed by the parties. Had you reviewed this exchange before you filed your direct testimony on August 7th in this case?
No, this came to light, this transcript came to light through the evidence testimony filed by Mr. Larkin Connolly. I did not see it before I filed my direct.
Okay. And in reviewing your rebuttal testimony, it appears that it's probably fair to say that this exchange did not change your opinion of whether or not there was a commitment in this case. Is that a fair characterization?
Yes, that is my conclusion. It's also addressed by the company's other witness in rebuttal. So yes, did not change my opinion at all.
So it's your view that when a commissioner seeks confirmation from a witness as to the meaning of a provision of a settlement, and the witness indicates his understanding to the satisfaction of the commissioner, that that's not germane to a subsequent review of what the provision means?
Oh, I think it's germane. And I think, again, the reference here multiple times to Mr. Cook's testimony, and that is the program that they're talking about. So when the witness, Mr. Chapman, says, yes, that's how it was discussed, how it has been discussed by the parties. I think that was a truthful and accurate statement. Again, there are many plans, there are many intentions, but that was how it was discussed by the parties, that was the intention of the company. And that, I think, again, is laid out in witness Cook's testimony in that case.
With respect to intent, looking at this exchange here, you would agree that, let me strike that. With respect to intent, your testimony is that it was notwithstanding the statement of intent, it was within the company's prerogative to of whether or not to completely replace all inside Mercury service regulators in a 10-year program based on their operational prerogatives. Is that right?
Yes, if I understand your question, yes, I think that is it within the operational prerogatives of the company to delay that program, to modify its intent as operational issues arise. It's my understanding that actually that was OPC's position too, from your response in the motion to show the order to show cause, where you talked about some number of years of slippage would be acceptable. So I think there's a recognition here that certain items are within management's discretion as to the timing and the prioritization of spending. The question you're asking, is this language relevant in interpreting the company's intent? Certainly it is.
And you would agree, sir, just to get back to something you just said, that the issue of whether or not it's acceptable for the company to have, to use your term, a few years of slippage, that's a different issue as to whether or not it's acceptable for the company to not complete the program within a 10-year period, correct?
Well, I think that's what a few years of slippage means, is it would not be completed within the 10-year program.
Well, of course, there's always the opportunity for a utility to make up for the slippage.
That depends on when the slippage occurs.
Fair enough. When Mr. Chapman discusses the settling party's intent, however, you would agree that the parties don't have any input as to operational prerogatives of the company, as discussed in your testimony, such as when there's a leak issue.
You're right. The company is responsible for maintaining and operating the company safely. That is and should be their responsibility.
Okay, so the settling parties in this case understood that the intent was to complete the program, but they of course couldn't affect whether or not the program was completed or not, correct?
I think that's correct. Again, it is up to the company to safely, efficiently, prudently operate the company. That's their job, and again, I think that's the way it should be.
Okay. Let me ask you, wrapping up on one more question on your direct testimony, and then a couple things on your rebuttal, and then I should be able to wrap up. On your direct testimony, bear with me a second. On page 7,
Okay, I'm there.
okay, you say here on line 20, you say the company has explained that it's been replacing MSRs since the early 2000s. Specifically since 2004, 86% of the MSRs in Maryland have been replaced. Do you see that?
I do.
When you say 86% of the MSRs in Maryland have been replaced, what you really mean is that 86% of the revised estimate from case number 8959 have been replaced, correct?
I'd have to go to Mr. Murphy's testimony at page 14, which is again the footnote here to verify that that's the docket number. But generally, that's my understanding.
Okay, because in this case, I mean, the company doesn't present an estimate in this docket 9622. You're aware of that, correct?
That's right. It says it needs to do field verification of the number of MSRs that remain in place.
Okay, thank you. Now, if I could refer you to your rebuttal testimony.
Certainly, I have that.
I'm getting it now. Bear with me one second, please. All right. You have a comment here. I'm looking at page 2, on line 18 of your rebuttal. And you say here that in his direct testimony, Mr. Larkin Connolly, referring to OPC's witness, sets forth a flawed understanding regarding the company's obligations under prior rate case settlements and traditional rate making, going so far as to suggest that the commission itself would be remiss and risk tarnishing the integrity of the state if a penalty is not assessed in this case. Can you tell me where in Mr. Larkin Connolly's testimony he says that the commission would be remiss and risk tarnishing the integrity of the state of Maryland if they don't assess a penalty in this case? Where is that?
If you look on page 6 of his testimony, which is cited directly above that question, we have the statement that says, I recommend the commission assess a civil penalty of at least $1.54 million and suggest that to maintain the integrity of the Maryland regulatory process, an even higher penalty be assessed. That's the language I'm referring to.
Okay, that language doesn't use the word tarnish, does it?
No, it talks about maintaining the integrity. Tarnish would be what happens in the absence of that action.
Okay, and he doesn't say anything about the state of Maryland, but rather the Maryland regulatory process, correct?
Give me just a moment to go to the original source here. phrase he uses is the Maryland regulatory process. I view that as being the process of the state. So if your question was, does he talk about the state? Yes, I think he does.
Have you ever heard somebody use the phrase Maryland regulatory process as a synonym for the phrase state of Maryland?
I think it means different things in different contexts. I've explained to you the basis of my statement.
Other than the portion of Mr. Larkin Connolly's testimony that you cite in your rebuttal testimony that you've just referred us to, is there any other place in Mr. Larkin Connolly's testimony from which you glean or interpret that Mr. Larkin Connolly is saying that this commission would tarnish the integrity of the state if it doesn't impose a penalty in this case? Anywhere else?
Yes, it also appears at page 36 of his direct testimony at lines 15 through 17. Where again, he makes essentially the same statement that I also suggest that based on the issues surrounding the integrity of the Maryland regulatory process raised in this case, the commission consider an even higher penalty.
Right, but again, he doesn't say anything about the state of Maryland, and he doesn't use the word tarnish, correct?
No, he uses the phrase, the issues surrounding the integrity.
Okay. Sir, you spend a lot of time in your rebuttal testimony talking about merger commitments. We've been going a while now, and I don't want to go through all those, but let me just, as it was brought to light earlier in the discussion of whether or not you needed to be qualified, and you were a witness in case number 9449, the docket concerning AltaGas's proposed acquisition of Washington Gas, right?
Yes.
Okay. And you're aware that the proceedings in that case were governed by Section 6105 of the Public Utilities Article. Do you recall that?
I'd have to verify that reference, but I'm generally familiar with the provisions governing mergers and acquisitions, changes of control within Maryland.
Okay. And when you entered an, or not entered an appearance, but when you were designated as an expert in that case, you presumably familiarized yourself with the fact that there had been previous mergers in Maryland under that were subject to the merger statute 6105. Is that fair to say?
I did familiarize myself with that, yes.
Uh-huh. And do you recall from that case that the standard that's set forth in Section 6105 is whether a proposed transaction is consistent with the public interest, convenience, and necessity, will result in no harm to customers and will result in benefits to customers. Do you recall that?
Generally, yes.
Okay. And would you also agree in reviewing the AltaGas case in which you were a participant and other previous mergers that it's common for the commission to impose a series of conditions on the applicants in a case like that as a condition for the commission's approval? You're aware of that?
I'm only troubled by the use of the word impose. Most of the cases have been resolved through settlement where the parties agree to take on conditions and commitments. I'd have to go back and check how many have actually had those imposed by the commission.
Well, in the AltaGas case, just to take that one, for instance, you recall that there was a settlement. You recall that, correct?
I do.
And many of the provisions of the settlement ended up as ultimately as the conditions that appeared in Appendix A to the commission's order, right?
Correct.
Okay, but then the commission itself, based on its review of the settlement and its review of the case, ultimately imposed some additional conditions. Do you recall that?
Yes.
Okay. And when the commission in the AltaGas case or previous Maryland utility acquisitions, when the commission imposes conditions, it typically refers to them as necessary to bring the proposed acquisition into compliance with the governing statute, correct?
I'd have to have a source to verify that language.
Okay. I can move on. Would you agree that one of the reasons that it's important for a commission to incorporate conditions, whether the product of a settlement or whether imposed by the commission sua sponte, one of the reasons it's important, not the only reason, is because oftentimes the holding companies that acquire the utility in question aren't subject to commission jurisdiction?
That was a long question. I'm sorry. Can I have that again?
Yeah, would you agree that one of the reasons that it's important for a commission to incorporate conditions from a settlement and even to sometimes add its own conditions on top of those in an approval of a utility acquisition is that typically the acquiring company, the holding company, is not itself subject to the regulation and jurisdiction of the commission?
For a few of the merger commitments or conditions, it is relevant that there's a holding company and that the holding company typically is not jurisdictional to the commission. That's not applicable to the vast majority of the merger commitments, but it does relate to some of them, yes.
Okay, fair enough. And kind of conversely, when there's a base rate proceeding involving a distribution utility that is subject to the commission's regulation, you would agree that it's not common for the commission in a rate order following a base rate proceeding to include as an appendix a long series of conditions and commitments to which the utility will be held. Would you agree that's not common?
That's correct. It's not common because that's not the purpose of the proceeding. The proceeding is to establish rates, which will then go into the rate schedule and terms of service, the tariff of the utility. But typically, again, utility rate proceedings don't establish commitments of the nature that we talk about in mergers, where, again, there's clear language with regard to the standard to be met, an unambiguous commitment to meet it, and clear consequences of not meeting it.
Is it your testimony that in order for a commitment to be binding, regardless of the type of commission proceeding, that the express consequences have to be stated in the relevant commission order?
I'm sorry.
Excuse me. Yeah, right. Let me ask the question differently. So just listening to your last answer, is it your testimony that in order to be binding, a commitment that a utility makes has to entail an express statement of the consequences of noncompliance?
No, sometimes those are established again through statute or rule of the commission or of the state in which the commission operates.
Mm-hmm. Going back to your answer of 2 answers ago, let me also ask you. You were drawing a distinction between base rate proceedings and merger acquisitions. Is it your testimony that base rate proceedings never result in binding commitments on utilities?
No, sometimes they do. Again, there are examples of accounting orders within rate proceedings for the deferral of cost or for the creation of a regulatory asset. There are commission orders on rate matters that speak to the establishment of special recovery mechanisms, such as strides, such as a purchase gas adjustment clause. So yes, there are binding commitments and obligations that are established through rate proceedings, but again, different from what we are talking about here in the show cause order.
Well, what about, aside from the examples that you just cited, what about a commitment flowing from a settlement agreement?
You'd have to be more specific. As the chairman pointed out early on, you've been a witness in a great number of cases in your career. Have you seen
a settlement in a base rate case result in a settlement agreement that included a commitment on a utility that was binding?
Certainly. I've seen commitments that say, for example, you will file a compliance filing within the next 60 days. I've seen commitments that say you'll file a cost allocation manual or affiliate code of conduct within X days. Or as we saw in case 8920, a commitment to file status reports with the commission. So again, there can be enforceable, understood commitments within rate proceedings.
And thank you. And to wrap this up, the reason that you view the commitment to file the annual reports associated with the replacement of mercury service regulators that's contained in paragraph 11 of the revised stipulation in case number 8920, you view that commitment differently than you view the statement about the actual replacement of the regulators based on the language used. Is that fair to say?
Yes. And with regard to the language used, plan to me is different than commitment. And in industry conduct, again, with regard to operations and spending and the inclusion of cost and a revenue requirement, that does not, in my experience of 44 years in the industry, create any obligation on the part of the utility to spend that money on those items in those years. That's not the way in which rates are established. Rates are established, as I've said, at the level of rates, not at the level of earmarking the individual components of revenue requirement that are used to develop the rates.
Yeah. I understand your testimony on earmarking and the development of a revenue requirement, but my question, and let me ask it differently. Based on the settlement agreement alone in 8920 and reviewing that agreement, your view is that the reporting requirement should be considered a commitment because of the language used, but the actual replacement program and the 10 years should not be considered a binding requirement because of the language used in the settlement agreement. Is that fair to say?
Among other things, as I said, the language in the settlement agreement is important to me, but also the nature of industry conduct. Once rates are settled and once rates are established, there isn't, in my experience in the industry, any mandate to spend the funds in the revenue requirement on those specific items in those specific years.
Let me ask it this way. One more hypothetical, and then I promise to wrap up. If the settlement agreement in 8920 had said, hold on, let me actually get the settlement agreement before me, and so I can avoid doing this twice. Bear with me a second. Looking at paragraph 11, let's assume the first sentence was the same. If the second sentence said the company commits to complete the change out within 10 years, would your testimony be different in this case?
We're talking about paragraph 11 of the stipulation in 8920.
Yes, the revised stipulation.
And you're asking me, I'm sorry, what if we change
sure.
which sentence?
If the second sentence said the company commits to complete the change out within 10 years, would your testimony in this case be different?
My testimony regarding a commitment probably would be different, and I expect the company's conduct would have been different. So many things I think could have changed and could have been different if that was in fact the obligation created under this settlement agreement.
Okay. Thank you. Mr. Reed, I don't have any further questions. Thank you, Your Honor. In terms of Your Honor, I believe all the exhibits I referred to were documents from the earlier base rate cases. I don't believe I used any data responses from this case. And I did refer to one of Washington Gas's exhibits. Along the lines of what Your Honor said to AOBA Council about waiting to see, what comes in from the company, would the commission prefer that so that we don't have all these duplicate exhibits and we can, see what came in from the company, and OPC could perhaps, when it makes its case in chief by calling Mr. Larkin Connolly at that time, could, to the extent necessary, move any of these materials into evidence?
I'll allow you to do that in this proceeding. We do have a lot of duplicate pieces of evidence marked by a number of the parties. We don't need 4 sets of the same document cluttering up the record. So I'll allow you to reserve that right, and similar to AOBA, and to raise that at a future date. I'm not going to raise it for you, but at a future time, you may seek to move those documents into evidence.
Thank you, Your Honor.
Thank you. We've run a little long, and we went through the morning break. So at this time, I'm going to combine the morning break and the lunch hour together, at which point, after lunch, we'll resume with cross-examination by Commission and Staff Counsel, followed by redirect by Washington Gas Light. So we'll take the next 40 minutes. We will recess until 12:30 p.m.
Your Honor, before we recess, I believe Mr. Buckley had his hand raised.
Your Honor, I just have one more administrative matter regarding Mr. Reed, which it might be convenient to handle now before he might disappear.
Well, he needs to come back at 12:30.
Okay, we'll take it up then. Thank you, Your Honor.
Okay, and of course, Mr. Reed, do not have any conversations with your counsel during this break. Thank you.
Understood.
the folks is that
We will go back on the record in about 2 minutes. Welcome back. This is a continuation of case number 9622, the trial type evidentiary hearing. We're back from our lunch recess. In terms of the rest of the day, we're planning to go until about 5 p.m. We'll take another break or two as appropriate. At this point, before we begin the redirect of our staff counsel, Mr. Buckley, did you have a matter to address?
Your Honor, there was just one administrative matter with Mr. Reed I thought we could take care of really quickly, and since you've opened the floor, let me do it. Mr. Reed is unavailable tomorrow due to a prior conflict, so we just simply wanted to apprise the commission of that. We certainly understand that that would limit our ability to have him address any rejoinder for testimony in these couple of days, so we understand that we're losing that right, but we would simply ask the commission's permission that at the end of today that Mr. Reed be excused.
Okay, thank you, Mr. Buckley. We'll revisit that before close of business today. At this point, we will turn Mr. Reed over to the cross-examination by staff counsel. Your witness.
Hello, this is Mike Dean, staff counsel. Your Honor, do you wish me to get a few documents into the record first from your discussion with AOBA? That could be done quickly here.
Why don't we do that? Yes, Mr. Dean.
Okay. Good afternoon, Mr. Reed. Could you turn to page 2 of your direct testimony, line 20?
Yes, I have that.
And here you are referencing the settlement stipulation and agreement from case 8920, dated July 30, 2002.
That's correct.
Is that correct?
Yes.
Mr. Reed, did you hear me?
Yes. Could others hear my answer?
Oh,
We could hear you, Mr. Reed. Mr. Dean, you may have had some trouble hearing his responses, but he's been answering you.
oh, thank you. Your Honor, that this document was included as exhibit number 6 in the staff exhibit list that was submitted. Do you want me to continue to use the same numbering?
When you say same numbering, do you mean marking it as staff exhibit number 6?
Yes.
Yes. Why don't?
Or- Okay, I'll mark this as staff exhibit number 6 then, and request that it be entered into the administrative record.
Hearing no objection, staff exhibit number 6, which is settlement and agreement of case number 8920 from 2002, is so marked and admitted.
Mr. Reed, could you turn to page number 3 at lines 24 to 25? Is it true that this is referencing the revised stipulation from case number 8920 filed on August 6, 2002?
I'm sorry, you're in my direct testimony, page 3, lines 24. I show the pages ending on line 24.
Excuse me, that would be page number 4. I'm sorry.
Oh. Yes, that is correct.
Your Honor, I'd like to mark this as staff exhibit number A, being the revised stipulation from case number 8920, and request that it be moved into the record.
So marked as staff exhibit 6A. Hearing no objection, it's moved into evidence.
And then lastly, on page number 3 of your direct testimony on lines 19 through 22, you're referencing the direct testimony of Mr. Cook of the staff from case 8920. Is that correct?
That's correct, yes.
Your Honor, I'd like to mark Mr. Cook's direct testimony dated March 28, 2002 as staff exhibit number 7.
So marked as staff exhibit number 7. Hearing no objection, it's moved into evidence.
And that's the completion of that part. Mr. Reed, I have no intent to ask any questions that would require confidential answers, but if that would require that, could you please notify us?
I will, yes.
From your direct testimony, your attachment of your resume and professional history, I note that this is marked as confidential. I assume that's just a clerical error at the top of the page?
Yes, I'm not sure why that's marked as confidential. It should not be.
Thank you. For the cases that you cite, is it true that none of these include whether you testified on the imposition of civil penalties?
There is no regulatory proceeding that I've appeared in on which I addressed, or even that the topic came up of the imposition of civil penalties.
So
They
this,
have been in civil cases, but not regulatory cases.
thank you. So this would be your first time testifying an administrative proceeding on the imposition of a civil penalty then?
That's correct.
Thank you very much. Turning to page 3 of your direct testimony.
I'm there.
I think when we're entering documents at line 15, this quote, block quote right there, that's from the stipulation, correct?
Yes. The stipulation in 8920.
Thank you. And then turning to the next page, the quote at the bottom of the page, that's from the revised stipulation?
Yes, that's correct.
And do you know whether or not on the revised stipulation it's a separate paragraph as it is shown here?
No, I'd have to consult the source document to see if that was part of a larger paragraph.
Would you accept for check that it is attached to the quote, block quote on page 3, the as item 10 from the revised stipulation?
Give me just a moment. I can accept that.
And in this statement from the, which was added at the request of the commission, the section at the bottom of page 4, it says further commits. Would you take that as the commission at that time believing that the entire paragraph there on page 3, term 10 from the stipulation was also a commitment?
Your Honor, not an objection. I'm not sure I understand counsel's question. I thought Mr. Dean was asking if Mr. Reed believes something about the commission's perspective or the commission's belief. I'll hold my objection and request through the bench a clarification.
The counsel should not be asking what the witness believes the commission to be acting on. I'm not sure that's what Mr. Dean was asking, though. Mr. Dean, if you could please rephrase.
Thank you, Your Honor. That was a good objection. In your analysis of the stipulation, why do you think it says further commits for the section that's on page 4?
I think it's distinguishing that additional action item, the commitment to file a status report, from the intention stated and the plan stated in the prior sentences.
Thank you. I'll move on then. On page 9 of your direct testimony.
I'm there.
At question 22, you define traditional rate making, and then on the next page, on question 23, at lines 14 through 15 on page 10 here, are you indicating that when Washington Gas when Washington Gas fails, when funds are specifically specified for use in a project, that it fails to meet the safety and reliability obligations such that the commission can determine if remedial actions are necessary?
I'm troubled by the first part of your question about funds. My statement there beginning at line 14 is if the company fails to meet that obligation, which is the obligation to provide safe and reliable utility service, then the commission can intervene and determine if remedial actions are warranted. So that's true without regard to how the underlying revenue requirement or rates are developed.
Thank you. Could such remedial actions include a civil penalty?
Yes.
Thank you. Turning to page 14.
I'm there.
At the question answer number 31 at the bottom of the page, lines 20 through 22, is it true that you have concluded that Washington Gas should have notified the commission that it was essentially deferring work on the Mercury service regulatory the replacement program to address other system leaks?
My conclusion is that it's reasonable to expect that the company would have informed the commission of the cause and effect of this reprioritization. I'm not quite sure if your question went beyond that.
No, that's a complete answer for my question. Thank you. Turning to page 17. I believe starting on this page, your questions and your answers have different numbers on them. From now on, I'll be just using the question number.
Yeah, I'm sorry for that. That's odd.
On page 18, for question 40 at lines 9 through 10, did you assist in determining the suggested civil penalty of $36,500 per year for failure to file a report?
No, I did not.
Thank you. That eliminates a lot of questions. At question number 41 on the same page, you suggest items that would be included in a Washington Gas enhanced report. How often do you believe this enhanced report should be filed?
I think an annual frequency would probably be adequate.
Are there any things in this list here that you believe would make this report non-public in any way?
The location of the individual MSRs could probably be reported in a fashion that didn't result in any loss of privacy. So I think that probably could be managed. Let me just look at the rest of the items. No, I don't think that anything else on this list would require confidential treatment.
Thank you very much. Could you now turn to your rebuttal testimony?
I have that.
Turning to page 3, question and answer number 8 at line number 9. When you state commitment, you're referring to the further commitment from the revised stipulation in case number 8920?
Yes.
Okay, thank you. On page 4, at question number 9, you reference the AltaGas WGL Holdings merger commitments, and this is a case that you provided testimony in. Is that correct?
That's correct.
And you're an expert witness testifying regarding the commitments in that case?
Yes, that's correct.
Are any of the commitments from the merger case applicable to the Mercury Service Regulator Replacement Program in this proceeding?
Not directly. The provisions with regard to, again, maintaining safety and reliability are there, but there's nothing specific to the Mercury Service Replacement Program.
Thank you. On pages 6 and 7, and also as an attachment, you include several of these merger commitments. What is the purpose of including them in your testimony?
To show how commitments that are understood in advance to be enforceable commitments with clear consequences if you don't meet the commitment are typically established. They're established, again, with clarity, with an understanding that they are different than a plan or an intention. And again, I use statements here from rate cases with regard to capital structure or dividend policy or interest cost. There are many statements like that in rate cases that go to what the company's plan is. But when you, for example, in a merger case, make a commitment that, for example, the equity ratio will not fall below 40%, or you will engage in all of these remedial actions, and you may no longer be able to pay dividends, for example. That's a good example of where a plan or an intention, as communicated in a rate case, is transformed into a commitment with, again, very significant consequences. So it's meant to distinguish between those types of plans and general statements and intentions in a rate case from when that, in fact, does get transformed into a commitment with serious consequences if you don't make it.
Thank you. Could you turn to page A7 in your attachment of the commitments from the merger case?
Yes, I'm there.
Commitment 10A. Is there anything in this commitment written here that would suggest it's not a valid commitment?
Some of the language of 10A is permissive rather than explicitly requiring something. For example, language that says that the parties may file with the commission. So again, there is language here that is both prescriptive and permissive.
Thank you. The first part of 10A is directions toward the Maryland Energy Administration, MEA, and regarding meetings and filing a report on those meetings, correct?
Yes, General.
And the second part of this commitment is a 10-year program by Washington Gas to expand its system into new areas with a cap of $7. Is that correct?
Yes, it's described as investing up to $70 million. So I guess you can interpret that as a cap.
How is this commitment different from the term 10 from the case 8920 stipulation, which requires a change out of service regulators over a 10-year period with a estimated price?
There are a number of differences. Again, as we see in this paragraph, the funds, the term is established that Washington Gas shall expend up to $70 million within approximately 10 years. So again, the language is less prescriptive than in the prior or subsequent commitments here in the merger. I think it is, in that regard, if you will, similar to the plan that's established for mercury service regulator replacement. It recognizes that there's uncertainty with regard to the dollar amount and the time frame. And then here, there's also reservations with regard to the regulatory treatment of those costs, which is different, I think, than on the MSR expenditures. But in general, this paragraph 10A recognizes some degree of uncertainty on the dollar amount and on the timing.
Thank you. Thank you for your testimony here. Staff has no further questions. Thank you.
Thank you, Mr. Dean. Mr. Dodge, do you have any redirect?
I do. Thank you, Your Honor. Mr. Reed, can you still hear me?
I can.
OPC's Mr. Cleaver asked you a series of questions regarding the use of the Commission's phrase stated commitment in various orders in this case. Do you recall Mr. Cleaver's questions?
I do.
This is a show cause proceeding, is that correct?
Correct.
What do you understand is Washington Gas's opportunity to be in response to the Commission's show cause order in this matter?
Sorry, you asked, what do I understand Washington Gas's opportunity
to be in response to the show cause order?
It is being provided with an opportunity to respond to the statements of the Commission with regard to fulfillment of obligations, with regard to the remedial program, with regard to whether a fine should be imposed. So it's specific to the actions outlined in the Commission's order.
The orders that Mr. Cleaver cited to you and walked you through were issued in certain circumstances before the filing of your direct testimony and before the filing of your rebuttal testimony. Is that correct?
Yes.
Both of those testimonies that you filed include lengthy discussions of what constitutes an enforceable commitment. Is that correct?
They do.
Mr. Cleaver also questioned you about a letter from Mr. Price of Washington Gas to Mr. Clemenson of the PSC staff. Do you recall that line of questions?
Yes, I do.
Am I correct that the letter from Mr. Price preceded in chronology or or on the calendar the issuance of the show cause order in this proceeding?
If you'll give me just a moment. It's my understanding that the show cause order was dated September 5th, 2019. So the answer to that is yes.
Thank you, sir. Mr. Price's letter discussed some changes to the company's O&M manual, and you were questioned about that by Mr. Cleaver. Do you recall those questions?
I do.
To the best of your knowledge, Mr. Reed, did the company change its O&M manual as part of its original MSR replacement program?
Not to my knowledge, but that really goes beyond my research as to what was done at that time.
Thank you. Mr. Cleaver also asked you a series of questions about Mr. Klein's testimony in case number 8920. Do you recall those questions?
I do.
Mr. Klein's testimony about which you were questioned preceded the settlement in that case. Is that correct?
Yes.
Mr. Cleaver also asked you questions about Mr. Chapman's testimony in favor of the 8920 settlement. Do you remember those questions?
I do.
Do you believe, based on your review of the transcript through which Mr. Cleaver walked you, that the issue of unilateral authority of Washington Gas to change the MSR replacement program was settled in that exchange between the chief hearing examiner and Mr. Chapman?
No. I think Mr. Chapman, again, first referred back to the company's evidence as the source of his understanding of what the company's plan and intention was. But I do not believe that that exchange either modified the settlement or further limited the company in some regard.
Turning now to Mr. Dean's questioning. First, Your Honor, I will note that in describing Staff Exhibit 7, I believe Mr. Dean characterized Mr. Cook as a staff witness when in fact he was a company witness. So just for the record, I'd like to note that clarification.
So noted.
Mr. Reed, Mr. Dean asked you questions regarding page 14 of your direct testimony. Could you turn to that page, please?
Yes, I have that.
Specifically, he walked you through your answer to question 31. Do you recall those questions?
I do.
And your testimony there regards notice to the commission of the pivot to the unprecedented leaks in Prince George's County. Is that correct?
Yes, it is.
And do you believe a civil penalty is warranted attributable to the company's failure to notify the commission?
No.
Excuse me, it's the court reporter. I lost the connection after the question was, thank you. Mr. Cleaver also asked you a series of questions about Mr. Klein's testimony in case number 8920. Do you recall those? And then I lost my audio.
I'm happy to go back in time, Mr. Chairman.
Mr. Dodge, if you could recall that question and piece it together, that would help. Thank you.
I'll do my best. Thank you, Your Honor.
I don't know what happened, so. Okay.
I'll repeat my question about Mr. Klein. Mr. Reed, Mr. Cleaver asked you. Linda, can you hear me?
Yes, sir, I can. Thank you.
Thank you. Mr. Reed, Mr. Cleaver from OPC asked you questions about Mr. Klein's testimony in case number 8920. Do you recall those questions?
I do.
Mr. Klein's testimony testimony preceded the settlement in case number 8920. Is that correct?
Yes, it did.
Mr. Cleaver also asked you questions about Mr. Chapman's testimony in support of the 8920 settlement. Do you remember those questions?
I do.
Do you believe the issue of the company's unilateral authority to change the MSR replacement program was settled in that exchange?
I don't believe it was modified or by settled in some way, meaning resolved. Mr. Chapman referred to the testimony of the company witness sponsoring the replacement program, but I don't view that exchange with the hearing examiner as modifying or amending the terms of the stipulation agreement.
Thank you. Turning now to staff's questioning, as I noted before, Your Honor, staff counsel referred to witness Cook as a staff witness in describing Staff Exhibit 7. Mr. Cook was actually a company witness.
Should so reflect.
Thank you, Your Honor. Mr. Reed, if you would be so kind as to turn to page 14 of your direct testimony.
I have that.
Mr. Dean asked you a series of questions regarding your answer 31 on page 14. Is that correct?
He did.
And your answer spoke to the lack of notice from the company as it pivoted to address leaks in Prince George's County. Is that correct?
Yes.
Do you believe that that lack of notice should subject Washington Gas to a civil penalty in this matter?
No, I think that type of pivot is within typical discretion afforded to management with regard to its maintenance programs and its expenditures. I think, as I said here, it's reasonable to expect that the company would have informed the commission of the cause and effect of the new focus on leak detection and repair, but that failure to provide that notification doesn't rise to what would justify a civil penalty in my mind.
Mr. Chairman, that's all the redirect I have for this witness. He is available for commission questions.
Thank you, Mr. Dodge. Briefly for Mr. Reed. Mr. Reed, in reviewing your rebuttal testimony, you referred to commitments in various forms, including regulatory commitments, explicit commitments, and firm commitments. And is it fair to say that your use of an example of a merger commitment would cover those three categories of commitments?
Yes.
Earlier, in response to Attorney Caldwell, you testified that in this case, the MSR replacement program reflected more of an expectation, an intent, and a plan. Is that correct?
That is correct, yes.
In your experience as an expert witness, when a proposal is made by a utility and a utility commission approves that proposal or that plan, at that point, does that proposal or plan convert to a commitment?
No, not typically, where we're talking about seeking inclusion of a projected cost in rates, as we were in the rate cases that we've discussed here, 8920 and beyond. Obviously, the company is always careful in what it says in testimony, and it should be. But a statement that the company intends to spend X amount on any individual category of expenditures, whether it's one like this associated with the change out of regulators, or expenditures with regard to energy efficiency, or expenditures with regard to new capital on replacement or even expansion. I don't view any of those types of statements where, again, the utility is seeking to have cost included in its revenue requirement as transforming that into a commitment to spend those funds in a test year, in a individual year, or in any period of time. That's, in my experience, over 44 years, as being within management discretion as to how those funds are ultimately spent. I think the commission, understands, and many parties need to be reminded of the fact that what these cases do is they set rates, and the rates are what are prescribed in the tariff, in the rate schedules in the tariff. That's really the entirety of what these cases are about. The statements leading up to the derivation of rates, form a basis for ensuring those rates are just and reasonable. But that's really what the process is about. So to take statements and to try and transform them into commitments to spend specific funds in a specific year, I think there are other vehicles for doing that. Stride is a good example for that. There are purchase gas adjustment cases, others where, again, in order to get recovery, you tie the expenditure of funds to an eligibility requirement that they be able to be qualified as eligible for recovery under that investment or expense tracker. But that's different. And so, no, I don't think those kinds of statements transform it into an obligation or a commitment.
Thank you, Mr. I recognize Commissioner Richard.
Thank you, Mr. Chairman, and good afternoon, Mr. Reed.
Good afternoon.
As you're well aware, one of the things we need, probably the major thing we need to decide is, whether or not a civil penalty is warranted, and and how much. And so we have some direction and guidance in the Public Utility Article 13201. But of course, it is based on whether or not there's been actually a violation or not. So what we've done, let's see if I'm characterizing your testimony correctly. We've heard a lot of reasons, that were spelled out by the Office of People's Counsel and staff as to why I think commissioners reasonably believe that there was a commitment or some kind of a promise made to conduct this replacement program. But essentially, you're saying that we were just mistaken, that we didn't actually put into place specific triggers to make this a true obligation? And
not as it's been characterized by others here, meaning an obligation to spend a specific dollar amount of money over a specific period of time. I mean, again, I think it's worth remembering that 96, 97% of the regulators have been replaced. A campaign was undertaken. Spending priorities did change, and spending was repurposed from this program to leak detection and repair. But if the commission at the time from 2002 had an understanding that that amount that was being approved either as a pro forma adjustment or as a line item in revenue requirement somehow represented a binding commitment to spend those dollars in that year or those years, I think that understanding would have been mistaken. That's different from the understanding with regard to the reporting obligation. And I've tried to make that clear. And your question started with one about finding the basis for and potential size of a fine. As I've stated in my testimony, I think a fine is warranted here. I think the proposed fine of $36,500 per year for a reporting violation is the appropriate level. So at the heart of this, what it says to me is, what is the violation? To me, the violation is the reporting violation, which warrants a different level of fine than one that would be applicable, especially where any matter of company safety, reliability, integrity was at issue. That's not the case here. I do think it's safety, reliability, integrity was at issue. That's not the case here. I do think it's a reporting violation. And as I've said, I think for that violation, a fine is warranted.
Okay. And to get to that point, a commission, and I'm going to again look at, particularly interested in page 10 of your testimony. Essentially, if I'm, again, characterizing this or summarizing it wrong, it sounds like a commission is essentially, we have a rate case, and at the end of that rate case, it really is now the funds that are coming in, the revenues coming in to the utility are all spent at the discretion of the utility, as long as it's meeting that obligation to provide safe and reliable service. And you do talk about if the company fails to meet an obligation, the commission can intervene. But then you go on, but it is not reasonable for any party to seek to verify that the company actually spent the funds on the goods and services that were included in the revenue requirements. And so, again, I'm kind of trying to reconcile these two fundamental, I guess, points that you consider in traditional rate making. How does a commission then, be able to act on what you say they should do, and that is, if find out if the company has failed to in an obligation to meet or failed to meet an obligation?
Well, I start with what comes out of a rate case, and of course, what comes out of a rate case, as I've said, are rates, tariff changes, rate schedule changes. If the company were in fact charging rates that were not the rates approved by the commission, or providing service under terms that were different than those established in its tariff, that's, in my opinion, a failure to meet an obligation. And the obligation is to provide service as called for under its approved and published tariff. But you're correct. My opinion, and I think the opinion of those that are, in this business for decades in the issue of regulation and rate making, is that once the rates are established, the funds that are derived from providing service are discretionary to the utility as to how they're spent within the overarching mandate of providing safe and reliable service or meeting any other state-imposed service obligations, efficiency, prudence, others like that. So yes, there are enforceable obligations that come out of a rate case, and those are to charge the rates pursuant to the terms established in the tariff. And to the extent there are a greater level of specificity for individual categories of expenditures like STRIDE or like a PGA, again, I think that's clear from the terms of the tariff. But you're quite correct that I think that issue of enforceability or the ability to review individual actions does not go to a line item earmark type of approach. The commission's not approving line item earmarks for individual expenditures, for individual categories of expenditures. It's approving the aggregate revenue requirement and billing determinants used to reach the derivation of just and reasonable rates, which are, of course, part of then the ongoing obligation to charge for service under those terms.
Okay, trying to get to this understanding of where you believe the level of discretion when you have a rate case. At least up to now, it seems like we've had a lot of very detailed discussion on what are going to be the reasonable and prudent expenses that'll be carried over from the historic test year and anything that's pro forma. So if at the end of the day it's really going to be okay, commission sets the tariffs, but then the company is then free to go off and really just run its company the way it wants to. We set it and then we're supposed to forget it. It seems like we're going through a lot of trouble in rate cases to get into these level of detail when maybe we should just be like, okay, what do you need to have rates to run your company in a safe and reliable way? So it's that discretionary level I'm trying to understand where you believe in traditional rate making, the role of the commission, stops.
It's a matter of judgment, of course, but I think the role of the commission is to ensure that the utility discharges fully and adequately its mandate as a public service provider, and that's providing ample amounts of service under just and reasonable terms, providing safety and reliability. Where you approve individual programs, for example, if you approve capital expenditure for DSM programs, for example, and you review after the fact in the next rate case that the company spent those funds and they achieved little or no benefit or didn't spend those funds, I think that is an appropriate area of inquiry as to whether those costs should be included going forward, even though they may have been incorporated into a test year. You always have the ability to say, the company didn't spend the money in the right ways or on the right things, or didn't do so prudently. And that speaks to whether those costs are included in rates prospectively. Where I would draw the line, Commissioner, is in saying that you don't look at an approved rate from 20 years ago and say underlying that rate was our thought that you were going to spend X dollars on X item. You didn't do it. That type of after the fact reconciliation does really rise to the level of saying this isn't approving rates, this is approving earmarked line item funds. And I think that's where I have to draw the line. The rate setting process, of course, is prospective. There is no retrospective process for saying what did each dollar get spent on, nor should there be. That really goes to the purpose of management versus the purpose of rate regulation. It is management's responsibility to use those funds wisely, prudently, and I think they did so here. As I've said in my evidence, I think pivoting to the higher priority leak detection was an important decision. I wish they had found a way to communicate the consequences of that. But when I look at the fundamental decision that was made in repurposing these funds, I have to look at it and say, given the assessment of risk, that was the right call.
Okay. Then with the reporting commitment, can you just tell me, I'm a little confused how you separate the reporting commitment from the action, the program that was supposed to be reported about. It seems to me on its face, the two should be together. So how do you pull out the reporting requirement and then say, well, that's an obligation, but the program is not?
Now, let me give you, again, an example that's a bit of a hypothetical, but I think it is realistic enough to be informative here. If, in fact, the company 3 years in or 4 years in had issued its report to the commission and said, here's what we spent, here's how many MSRs we took out of service, here's what we think is left. You will note, commission, that our spending level has gone down. The reason for that is because we have repivoted to the higher priority leak detection and repair. We're still fully spending. In fact, they spent quite a bit beyond their level of O&M costs that were included in rates. That's one of the reasons why their earned return was below their authorized return. But the benefit of having that report would have provided a platform for the discussion that could have taken place at that time about repurposing the funds and why that was the right way to pivot. So in my view, the reporting obligation is separate from the program. That's why you have a reporting obligation, so you understand if in fact these kinds of decisions have been made, or in fact if you've determined that the problem is larger than you expected or smaller than you expected. That's the benefit of reporting. It doesn't modify that the underlying program was a statement of intent and a statement of what the company planned and genuinely did expect to carry out until other things intervened. But the reporting relationship, the reporting here could have provided the platform for further discussion. You know, with 2020 hindsight, that would have been great to have. Didn't happen, but that's why I think it's distinguishable from the program itself.
Okay. Was it, do you think, a particularly, egregious omission that the company didn't report that we are going to suspend the replacement program and pivot toward the LEAP program? I mean, was that a particularly, an important part of the reporting requirement that the company did not undertake or did not do?
No, I don't think it's particularly egregious. I mean, I guess we start by noting that nobody else noticed that the report hadn't been filed in year 2 or year 3. We did have in the record in the first rate case after the program was created and in the second rate case and the third rate case, we had notification that the level of spending was substantially below what had originally been planned. But again, that's not an explanation as to why that occurred. So here, the fact that the reporting didn't occur on a timely basis, we're just now hearing the full story as to what happened. I don't view that as being particularly egregious. I think it's within the realm of the fine that I've endorsed here of $36,500 a year. So again, when you view it from the perspective of it's a fine for a reporting violation, I think we're in the right ballpark.
Okay, just one final question, and that is about the calculation of the fine. At this point, if I'm reading the commitment, these reports were to continue up until the completion of the program. The final MSR was replaced. So do you agree that that has not happened, and perhaps that some of the calculations by staff and OPC may be more relevant to our consideration than the one provided by the company?
Well, I think the company has a different view with regard to when that obligation would have ceased given the intervening rate case decisions. And I think they should really, that's a legal issue in my view, not one that's something that an expert can provide commentary on from my perspective. Again, even the $100 a day, as I understand it, is an up to. I think, again, you have to look at the severity of the infraction. You have to look at the reasons behind it. As Staff Witness Val Karengi has emphasized to you, you should understand that this was done in the context of pivoting to what really everyone at the time thought was a more serious problem. I agree with that sentiment. Okay,
but
in my view, that's again the right framework for making the decision here.
Okay, but you do agree that the commitment, the one fact I think we all agree on, said that the reporting was to take place until the completion of the program.
That was
is that a fact that you agree with that?
Yes, I agree that those were the terms of the original commitment.
Okay, and has the program been completed?
It has not.
Okay. Thank you. Thank you, Mr. Chairman.
I recognize Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Reed, I have a few questions for you. I want to start with a part of your direct testimony where you were responding to a question regarding what a DIMP is, and you get into some risk. There are some confidential parts there, and I don't want you to speak about the confidential parts. So my intention is not to get into those confidential areas, but I want to talk to you generally about your understanding of your testimony and the risk that you discussed. Is that okay?
Yes.
Okay. So, what is a DIMP?
It's a distribution integrity management program administered under guidelines established by the PHMSA, the Pipeline Hazardous Materials Safety Administration.
Would it be fair to say it generally gives you a risk assessment of your plant and components in your plant, and allows you to assess its viability or need for maintenance or replacement?
Yes, not just maintenance and replacement, but also safe operating limits. But that's generally correct, yes.
Among other things, of course. So obviously, when the commission approved this program, and there's no doubt in your mind we approved the program back in the early rate case in the early 2000s, right? To
Correct.
Replace these regulators. We approved that program. It was a programmatic approval. That we did so partially, at least, because the record indicated that there was some risk associated with these components. They had been suspect. Other agencies had complaints about them, and the company, through its own assessment, indicated that they needed to be replaced, and they laid out a 10-year, as you called, just a good-hearted intention, but it was a program to replace these things that the commission approved. Is that not correct? Because there was some risk associated with these MSRs.
Yeah, so let me take that as two parts. Yes, you're correct. It was a statement of an intended program. I think the risk, we may be mixing up apples and oranges here in terms of an environmental and health risk as opposed to a safety and operating risk. The company's technical staff was probably more in a better position to speak to that than I am. But my understanding, even from the beginning, was the assessment here was that it was an environmental and health risk as opposed to safety and operational risk.
And I think there's probably some truth to that, but there was risk. And there was even risk from an operational standpoint. It just may not have been as high as other parts of the system. But there was some risk there on both sides, environmental health and maybe operational. And I don't want to get into a discussion about the relative risk presentation, but when the program stopped, when the company exercised its decision to stop implementing the program that it promised to and that the commission had approved, what happened to that risk? Did it go away?
Two things. I don't think the company ever stopped the program. It spent less on the program, but it did continue it.
Well, it's 16 years later, or it's actually 18 years later, and we still don't have it done.
Right. Only 96, 97% of the units have been replaced at this point. But with regard to your question was, did the risks go away? No, to the extent that these regulators presented an environmental or safety, or I should say health risk, I don't think that risk went away, but you're always prioritizing your spending based upon your assessment of the severity of the threat. It's both a matter of severity and consequence.
Right.
And, you know, again, without getting into the matrix, which we're not going to talk about on the record, the severity and consequence is how you assess your priorities for spending. Here,
right.
You know, there were exigent circumstances that really caused those priorities to be reassessed and the spending to be reprioritized.
I didn't mean to cut you off, and I'm trying not to cut you off. I'm just trying to exercise a little bit of democracy of time with my colleagues. So I appreciate more concise answers if you could help me with that, so I don't take up too much time here. But what brings us here is a very high risk, very high consequence event in Silver Spring, Maryland. Very high. That maybe had the program been completed as promised, may not have happened. May not. I don't know for sure, but maybe not. I'm just a layperson. I'm not talking the lawyer talk right now. I'm just talking common sense. So let me go from there to understanding another part of your testimony. Another part of your testimony, I think, says, fine us for not reporting, but the underlying program that we were reporting on doesn't matter. It was discretionary. It could go away at the discretion of management. We didn't follow that report, you can fine us, but the underlying program that we were reporting on, so the commission could evaluate your promises, your commitments. Fine us for that, but don't fine us for the underlying program that it was reporting on. Is that your testimony?
Only partially. My testimony is that when you separate the reporting issue from the conduct of the program and the spending of the funds, you have to begin with an understanding. And I think this is an understanding that I share with OPC based on their comments, which is there is a degree of management discretion in how funds are spent that come out of any set of rates. We can talk about whether the company's conduct went beyond or outside that discretion. My conclusion is it did not. And my conclusion is it did it for a very valid reason. So yes, you're correct that my view is that the fine should be levied on the basis of an understanding that the transgression was reporting, not a failure to spend money on a specific program.
Well, it just seems to me like, yeah, we had a technical glitch that we didn't report, and you can smack us on the fingers for that. But that really important thing that led to maybe something else down the road that had risk associated with it may have been shifted to the customers who had these things in their homes. That's not important. But the report was important. You can fine us for that. And as a regulator, I'm having a real hard time trying to grapple with why that's in the public interest. So I appreciate your answers. I appreciate your responses. And I am not a lawyer, but I was in the legislature for a long time, and I know a little bit, sir.
Understood. I appreciate your perspective.
Thank you. Thank you.
I recognize Commissioner Herman.
Sorry, you surprised me. I thought Commissioner Linton was going next, but I'll jump in line if that's.
Oh, okay. Sorry, Commissioner Linton, I see your mic's open. If you'd like to proceed before Commissioner Herman.
I'm fine either way. I'm happy to be last or next. Commissioner Herman already started, so if you'd like to.
All right, I'll jump right in then. Mr. Reed, I'll welcome. Thank you for being here. I know you've been sitting in that chair for a while, as we all have. So appreciate you being here. Mr. Reed, I understand that it's your testimony that Washington Gas did not commit to spend X dollars.
I'm having a real hard time hearing,
Yeah,
Commissioner Herman.
Commissioner Herman, your mic is very, very soft today.
All right.
That's much better. Yeah. Actually, we might have lost you. Now we don't hear you at all.
Go to him. Can you hear me?
That's good.
Okay. Why don't you go to Commissioner Linton and I'll unplug my headphone set and we'll see if that works. So go ahead, Commissioner Linton.
Okay, sure. Thank you, Mr. Chairman, and good afternoon to Mr. Reed.
Good afternoon.
I had a couple of questions surrounding your testimony, your rebuttal testimony, and just so that I can understand the expert type of recommendation that you're proposing here today. In your rebuttal testimony, you've referenced some of the merger conditions that were incorporated in case 9449. That was the AltaGas merger case. You were a participant in that case. You testified in it. You recall that the company actually produced some of those merger conditions as part of their original application for the purpose of encouraging the commission to find that the merger was in the public interest.
That's correct.
And so as part of that, in order to support the conditions itself, the company presented a number of different witnesses that produced testimony under oath in front of the commission as part of our evidentiary proceeding in order to support that the company, the final merged company, would actually live up to those conditions. That you recall that as well as to be the purpose for those conditions?
I do, yes.
And the commission also, in finding that the merger was in the public interest, added a few extra additional conditions. I think it was more than a few, but there were several others that were added in addition to the ones that were proposed by the merged company.
Yes, I recall that.
So in this case that we're talking about here today, and the original proposal that the company produced back in 2002, the original adjustment to their revenue requirement, they effectively produced additional testimony under oath from witnesses and representatives of the company to encourage the commission to find that what they were proposing as their plan at the time was something they would proceed and go forward with. That, in your opinion, is that what you found to be also true?
Largely, the company was seeking a conclusion from the commission that the settlement was in the public interest. That included a statement that the replacement program was in the public interest. And it contained references, as we know, to the plans and intentions of the company in terms of how that program would be carried out. So, yes, I think within the bounds of those statements, that is what the company was seeking to have the commission approve.
So help me to understand that, and I know you've testified in many other proceedings around the country over extended period of time. Has it been what you found to be, has it been your experience that commissions, not just this commission, but even other commissions, have taken the words and testimony of representatives of the company at face value, basically under oath? They've stated this is what will happen, and the commission relies on that testimony in reaching its own decisions?
Understanding the context in which it said, yes, you should have an expectation that the statements are truthful, that you can take them at face value, I think was your phrase, with the understanding that when somebody says, you know, we intend to maintain a BBB bond rating, the answer is sometimes things change, okay? Does the fact that the bond rating may have slipped a notch in some cases, if that were to ever happen, does that mean that there's a violation of a commitment? I don't think it goes that far. But you're correct that the statements are under oath. They absolutely should be truthful. They can be taken at face value as the best representation of the company's plans and intentions at that time.
So I guess I'm struggling a little bit because you know, the BGE, the other gas company, major gas company we have in the state, we have a few other smaller, you know, smaller in terms of customer size and revenue companies. This issue, as we're describing and talking about it now, appears to be unique to WGL in the sense that, well, up until this point, we haven't had another company suggest to us, to my knowledge, that a proposal or testimony that they produce to the commission is flexible at some point in the future if the circumstances change and there's not the commission shouldn't have an expectation that the work as was presented in the testimony will be completed as the company stated to us that it would be. So I guess that's a statement. So let me give you a question along those lines. How do we proceed from here? I guess it's, if we're talking about future cases where the company will produce, in some cases, some of the same witnesses. Now, Mr. Chapman is still at WGL. You know, he's been before the commission on several occasions. And there are other representatives of the company that will come before us and testify. Should we be listening for magic words now to say commitment as opposed to something else? Or are we able to say that if the company comes to us and says, this is what we look to achieve, that's what it is? I mean, how are we supposed to look forward from here? Keeping in mind, just as an example, that the company currently has a rate case pending in front of the commission. I'm sure there are adjustments there. I have not reviewed it to know. And there may even be situations or proposals similar to what we're talking about here today that are in front of the commission now. Should we look for well-worded words of commitment and statements similar to what we saw in the merger proceeding, or is there some other threshold? I'm going to have several questions at once. So
no, Commissioner Lynn, that's a really good question about how to go forward. So let me try and take that in two parts. First, I think the answer is, let's be really clear going forward as to what is a commitment that warrants a civil fine, as is being proposed here. If the company makes statements about, we plan to add 30,000 customers over the next 5 years, or if it makes statements where it says, we plan to reduce our average wait time at the call center to below 12 seconds. I don't think anybody would seriously propose that those be turned into enforceable commitments that warrant a fine if you don't achieve them. You can evaluate the company's performance in future rate cases, but that's different than the level of enforcement we're talking about here. So it begins with being clear. It also then continues with understanding the role of management versus the role of the commission. As you said, I work with commissions all across North America, and I have a lot of my staff members that came from commissions, including chairman of other commissions. So it's important to understand that the left to and to prioritize spending that makes sense. You certainly can look at that in rate proceedings, in any proceeding, and say, we disagree with it, or we don't think you're achieving the productivity or the level of benefit that you should out of these expenditures. But ultimately, to suggest, as has been done by other witnesses here, that the use of a pro forma adjustment or the use of including something in a line item on a revenue requirement turns that into an enforceable commitment, that's the step too far. And I hope that the company and the commission can come to an agreement on, again, those respective roles and again on the clarity of what is an enforceable commitment, especially one that would warrant the imposition of civil fines. Having an understanding about that upfront is really essential.
So, and I think that's kind of where I'm trying to focus in this case. There's this is a bit of a shift, at least in my opinion, this commissioner's opinion, as to how we would interact with the company, especially when they've presented or offered an adjustment of some kind to their revenue requirement as part of a rate case. It would suggest that in the future we should expect, as part of their base application, statements or clearly worded language along the lines of what we receive in the merger case, along the lines of what's in your rebuttal testimony. We don't see that now, at least to my knowledge, we don't. And maybe it was in the most recent rate case and I just didn't see it in there. But I guess I'm trying to understand the ramifications of that type of argument, that type of position. And so I'm asking you as an expert and the person who's seen these types of, have seen issues similar to this in other places. Is this the kind of filings that you see other commissions receiving from their regulated utilities? Ones where when there's a very distinct set of statements about what's going to be accomplished with in rate cases with adjustments that are made or requested?
Most commissions have pretty clear differentiation between earmarked funds and general purpose revenue requirement funds. Earmarked funds, as we've said before, include many types of riders like STRIDE. It includes many types of trackers such as purchased gas or pensions or post-retirement benefits or many other. I mean, there are some states that now have more than 20 trackers and riders that go on top of base rates. There is a dedication of those funds to a purpose, and there's an inclusion of a level of funds that only represents the funds that A, are actually spent, and B, qualify for that treatment. So I think it's important, and you're right, this issue doesn't really come up very often as to, what's the obligation of the utility to spend the money that is provided for it or to it through rates and through the approval of rates. It's most often dealt with in the case of those types of earmarked funds that are the subject to those other riders. But I don't think here I could recommend to the commission that you try and take this to the next step, because the next step would be to say every line item in a rate case represents a commitment. It represents a representation from management as to this is the way those funds will be spent. And, I used examples in my direct testimony that were meant to show that there are many categories of expenditures that you would never want to apply that level of after the fact scrutiny to. Postage, paving costs, office supplies, all of those may have pro forma adjustments to adjust from a base year to a test year level. But that doesn't convert them into commitments to spend that on postage or office supplies or whatever. I know our intention here is to make sure we recognize the severity of the accident that occurred, but let's step back from that and say what really is the issue before the commission with regard to the show cause order and the issue of the fine. We're trying to put aside the consequences of the event and try to put aside hindsight and what could be 20/20 vision here. I like to look at the facts, and the facts I think are within the confines of traditional rate regulation. The funds aren't earmarked. Secondly, the company did make a commitment with regard to reporting. So I wouldn't want you to feel like I'm urging you to step away from recognizing that commitment for what it was. But to suggest that other companies or other rate cases really, is there a magic word? No, there's not a magic word, and there shouldn't be. The answer is you should be establishing rates that provide for revenues sufficient to meet the company's mandate. But, let's not have essentially what could be considered after the fact micromanagement of management decisions. You don't want to do that. The company doesn't want that. That doesn't produce the best results. I do think your ongoing supervision and monitoring of the company's performance is really important. And ensuring that it meets its mandate to customers is really important. But ensuring that a line item out of a rate case is spent, to that level or at that period of time, that's where I suggest you draw the line. And again, based on my experience, that's where other commissions have drawn the line as well. To the extent you want tracked treatment, earmarked treatment, there are very workable mechanisms for dealing with that. That's not what we had here.
Okay, then, so I guess my final question then, if the commission does get into a point where they want to have a more defined commitment in the way that the company is, and you and your client are, and the testimony of today are defining the commitment, that would encourage us to not only demand or direct the company to produce the types of more legalese type of commitment in writing, reduce it to writing, and have more of a maybe even lift it out of a rate case, if you will, and place it somewhere else. So we're talking about treatment of a different nature than what we do currently. I mean, is that, and this is my last question, so is this the kind of approach the companies is suggesting that we take going forward?
I think that's a matter for you to decide based upon the importance which you attach to a program. I've suggested at page 18 of my direct evidence an enhanced reporting program. I think that's important as a first step to make sure that you have clarity as to what's being done and how much is being spent and what the timeline and work plan is going forward. That's not an intrusion in terms of representing micromanagement at all, in my opinion. That's a reporting relationship. You are entitled to that information. I think you should get it. If you think that the issue is one of importance that goes beyond that, I would suggest that you have an earmarked a tracked expenditure program. And there are examples through deferral accounts as well as through trackers. Again, OPC's witness Efren proposed a deferral account way back in 2003 for this program that wasn't adopted at the time by the commission. But if you feel that it's of a level of importance that you want to attach to it commission involvement beyond the enhanced reporting, then yes, I think doing an earmarked deferral account or tracker would be the way to go.
Okay, thank you, Mr. Reed, and thank you, Mr. Chairman. I have no further questions.
Thank you, Commissioner. Commissioner Herman.
Thank you, Mr. Chairman. Is the sound better now? Okay, thank you. Let me pick right up there, Mr. Reed, with where you ended with Commissioner Linton. If the commission accepted the plan that Washington Gas submitted to Mr. Clemenson on August of 2019, that I believe it was Company Exhibit 6A or 6, or Attachment 6, WGL Exhibit A, Attachment 6. You talked about that, I think, with Mr. Cleaver, the letter, right? So if the commission were to write in an order that it accepted the Washington Gas plan, is that a commitment or is that not a commitment?
I think accepting the plan as it's laid out there, I guess the short answer is, as I read that letter, and without going through it in its entirety, sort of line by line, it established plans with regard to what would go into the supervisor's manual, for example, for monitoring and ensuring compliance with the replacement program. Do I think, for example, a year into the program, if the company decided to enhance or modify what went into the supervisor's manual for that program, that would represent an unacceptable diversion or non-compliance with that plan? No, I don't. I think that
Mr. Reed, I'm trying to move things along pretty quickly here.
Yeah.
If the commission accepted that, is that a commitment on behalf of Washington Gas to complete the change out over the period of time that it's set forth in that letter?
Commissioner, with respect, I don't think the letter establishes a deadline by which it has to be done. I think it establishes a process for identifying the MSRs, for replacing them as quickly as possible, and for ensuring compliance. I don't think it has a mandate with regard to a specific date for replacing the MSRs that remain on the system.
So the answer is no, it's not a commitment.
I think it's correct. If you press me on commitment, I think it's a commitment to implement that plan. But
okay, let's stop there. Let's stop there. It's a commitment to implement that plan. Why is that any different from the implementation than the acceptance of the commission way back in case number 8920 to commit to implement a plan? Why is it different?
Again, 8920 was about a rate proceeding where
No, I'm not talking about the money. I'm not talking about the money. Putting the money aside, paragraph 11 of the settlement doesn't talk about the money. It just says we're going to change them out. We have a plan. We're going to follow the plan according to witness Cook's direct testimony. So forget it. Put the money aside. I'm talking about implementing a plan. Why is if one's a commitment and one is not?
Again, implementing a plan doesn't mean that the plan will proceed exactly as originally planned. The question in my mind is, was the management discretion here correctly implemented and reasonably implemented to pivot from that plan occurring over this period of time to a longer period of time, to repurpose spending? And I know you said you don't want to talk about spending, but that's what happened, was the repurposing of spending.
Yeah, I understand what happened. I'm just trying to understand, I'm just having a difficult time, as you can tell, a number of us are. The next question I have, I'll just move on. The next question I have is looking at the settlement language, paragraph 11, you've said in your testimony that words are really important, right?
Yes.
Okay. In the middle of paragraph 11, it says the company further commits, right?
Correct.
Further is modifying commits, is it not?
Yes.
Right. So further, what commitment are we furthering? Why aren't we furthering the prior commitment to do the change out?
I don't read it that way. I read it as saying the same thing as the company further commits that it will. So it has stated a plan and an intention with regard to the first two sentences. Again, those words plan and intention are quite clearly laid out in those sentences. It's saying above and beyond that plan and intention, we will commit. And that's a point of differentiation to me. It's not a point of somehow following on a prior commitment. It's saying above and beyond the plan and intention, we will commit to this report.
Okay. And I guess it might have been a little bit more clear than if further had been put in front of the company, further, comma, the company commits, right?
I can accept that would have been clearer.
Right. Okay. Thank you, Mr. Chairman. That's all I have.
Thank you, Commissioner. Based on the Commissioner's questioning of witness Reed, do parties have further examination?
Your Honor, the company does not at this point, except to say I would like to extend my sincere thanks. Those were all terrific questions, and I learned a lot in the discussions. At the same time, if other parties do have recross, I would reserve my right for redirect.
That right is so reserved. Any recross, Mr. Caldwell?
One question, if I may, Your Honor.
Yes, and based on who's questioning?
Based on Commissioner Richard's and Commissioner Herman's.
Please proceed.
Thank you. Purposes or reallocates funds intended for the regulator replacement program. Does the plan go away?
No. And again, I think here you see that spending did come back up after a period of it having been reduced.
So there's a commitment to complete the plan.
I would say not within a defined time frame. Do I think the 10 years was a mandated completion date? No. But do I think continuing the plan was part of what the company's original plan and original intent was? Yes.
You just can't say commitment, can you? I have no
I
further
don't think
questions.
there was a commitment, just to be clear. To me, a commitment would imply an end date, a completion date, and I don't think there was an end date or completion date there.
So the
Thank you.
10-year, I'm sorry. Thank you, Your Honor. Thank you.
Oh, okay, thank you. Any additional questioning? Mr. Cleaver?
No, Your Honor, thank you.
Okay, thank you. Mr. Dodge, any recross based on Mr. Caldwell's question?
No, thank you, Your Honor.
Thank you, Mr. Reed. This witness is now excused.
Thank
We're
you,
going to
Chairman.
take a break at this point. It's now 2 o'clock. We'll take a 10-minute break, at which point we will bring forward Washington Gas's next witness, who I believe is Mr. Murphy. So in recess until 2:10. In approximately 1 minute, we'll go back on the record. We are back on the record in case number 9622. Mr. Dodge, are you prepared to call your next witness?
Thank you, Your Honor. Every place I go, the buttons are in different order to get back on the platform. We are prepared to call our next witness, Mr. Buckley. We'll be sponsoring and defending that witness. Before I turn it over to my colleague, you used a key term when Mr. Reed was departing the stand. You said this witness is excused. We have not been in contact with Mr. Reed, nor will we be until he is formally excused. We would like to let him know if that's the case. And to thank him for his time and send him on his way.
Yes, that witness is formally excused from this proceeding.
Thank you, Mr. Chairman. And now I do turn it over to Mr. Buckley.
Thank you, Your Honor. Washington Gas calls Kevin Murphy to the stand, to the virtual stand. Good afternoon, Mr. Murphy.
Good afternoon, Mr. Buckley.
I presume you can hear me clearly?
I can. How am I coming through?
Coming through nice, but it's a little bit faint, so you want to make sure you keep your voice up or stay close to the mic.
Yes, sir.
Would you please state your business title and address for the record, please?
Mr. Chairman, excuse me, Mr. Buckley, Mr. Chairman,
Yes.
we need to swear this witness.
Well, yeah, we do, if the court reporter is available.
Can you hear me? Okay. Sir, do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
I swear.
Thank you.
Mr. Buckley, you may proceed.
Thank you, Your Honor. Now properly sworn, Mr. Murphy, do you have in front of you or with you a document labeled direct testimony of Kevin M. Murphy?
Yes, I do.
And that document consists of 30 pages of narrative questions and answers, as well as 3 exhibits?
That's correct.
And was that testimony and accompanying exhibits prepared by you or under your direct supervision?
Yes, it was.
Now, before we get to the matter of potential corrections, we know there's at least one regarding your title and your duties with the company. Would you take just a moment to explain the new title you have and the expanded duties?
Yes, on September 1, my duties were expanded to include our gas supply operations functions, which include operation and maintenance of our gate stations, our pressure regulating facilities, our propane air peaking, underground natural gas storage, our supervisory control and data acquisition systems, the automation group, and electronic communications, as well as the engineering group, who does design and construction of our gas supply facilities. And engineering also encompasses responsibility for transmission integrity management, system modeling, codes and standards, and materials engineering. And my new title is now Senior Director of Gas Supply and Engineering.
And a similar summary was presented in their pre-filed rebuttal testimony, correct?
That is correct.
Do you have any other corrections to make to your pre-filed direct testimony?
I have one on page 6, line 14. I describe, I'm referring to the testimony of in the two prior base rate cases, and I say replace all MSRs, and in the testimony in the two prior base rate cases that is being discussed, both of those witnesses describe replacing all inside MSRs. So I would add the word inside after all.
As corrected, do you adopt the testimony and the exhibits as your sworn testimony in this proceeding?
I do.
Your Honor, I'd like to ask that Mr. Murphy's direct testimony be marked for identification purposes as company exhibit number 3.
Marked.
And that it be received into evidence, please.
Hearing no objection, WGL exhibit number 3 is moved into evidence.
Mr. Murphy, do you also have in front of you a document that's entitled Rebuttal Testimony of Kevin M. Murphy?
Yes, I do.
And that document consists of 15 pages of narrative questions and answers along with 2 exhibits?
It does.
Was that testimony prepared by you or under your direct supervision?
Yes, it was.
And do you have any corrections to make to your pre-filed rebuttal testimony or the exhibits?
Again, I have one, and it is on page 2, lines 14 and 15. There I'm talking about other rebuttal presentations, and I incorrectly include rebuttal presentations from witness Turanimi. He, of course, did not submit a rebuttal testimony. So on line 14, I would remove the letter S from presentation. So rebuttal presentation of company witness Reed, and then strike and Turanimi.
As corrected, do you adopt the testimony and the accompanying exhibits as your sworn testimony in this proceeding?
I do, yes.
Your Honor, I'd like to ask that the rebuttal testimony of Mr. Murphy be marked for identification purposes as company exhibit number 4.
So marked, and seeing no objection, we'll move WGL exhibit number 4 into evidence.
And Mr. Murphy is available for cross-examination, Your Honor.
Thank you, Mr. Caldwell. Your witness.
Thank you, Your Honor. Good afternoon, Mr. Murphy, and congratulations on your promotion.
Thank you, sir.
Your Honor, I would like marked for identification what was preliminarily identified as AO Exhibit 3 and AO Exhibit 4. For the record, these are data requests which Mr. Murphy sponsored. I would ask that what was initially identified as AOB Exhibit 3 be now identified as AOB Exhibit 1.
Mr. Caldwell, just to make it easier, can we just keep it number 3 and number 4?
Okay, that's fine. That's fine. Okay, that's thank you, Your Honor. Mr. Murphy, do you have those data responses in front of you?
Yes, I do.
Okay. And in those responses, you state that Washington Gas did not agree and made no commitment or obligation to replace mercury regulators over a 10-year period. Is that correct?
That is correct.
How would you describe this approach?
I'm sorry, you broke up a little bit. How would I describe what approach?
Well, what Washington Gas, you didn't make a commitment. They didn't make an agreement. What did they do? What, if anything, did they do?
Washington Gas identified a set of activities, removal of these regulators that we believed it was in the interest of our customers and in the public interest. We were in the midst of a rate case and recognized that the test year did not include what we believed would be the right amount of expenditures, didn't reflect the right expenditures to do that work. But we requested an adjustment and submitted testimony that explained we think it's the right thing to do. We intend to remove these regulators. Here's the plan, the current plan. And we sought the inclusion of that item in our cost of service as witness Reed and has discussed.
I'm trying to get how did you identify the plan? I mean, you said it was identified and it's a plan, but what was Washington Gas?
I really lost you there on the back end of that. I'm sorry.
I'm sorry. My apologies again. Washington Gas identified a plan. Is that correct?
Washington Gas laid out a plan that really was indicative or a continuation of work it effectively had already started. But yes, it laid out its plan forward.
And that plan going forward included the replacement of all inside mercury regulators over a 10-year period. Is that correct?
At a high level, yes. I would say that it was described as our plan to replace all inside regulators based on our understanding of what the number of inside regulators was. Best information available at the time in 8920 was around 66,000. Of course, that was an estimate based on best information we had, and has been discussed, that estimate was, as new information came in, was revised downward. All has to be considered in the context of it's always going to be based on the best information we've got.
Understood, but I'm trying to get a description of what Washington Gas's, my word, not yours, commitment was to the plan. You're saying it's not a commitment. Washington Gas didn't agree. Was it a promise? Was it a wish? Was it a goal? How would you describe Washington Gas's approach to the plan?
So I'll, as I've said in my testimony, and I'll reiterate here, I'm not an attorney. I'm not a rate-making regulatory expert, but I have worked with this company for over 26 years, and when I read that language, I think the company, in a forthright way, laid out its intentions and its plan, and if there was a commitment, and again, I don't disagree with Witness Reed or Witness Toronimi or any of the other company witness. It was to act on our intention. That's what we were telling the commission. We were going to act on our intention to get these devices out of the system because they contain mercury, and we have. We've never we acted on our intention before that rate proceeding. And we've never stopped at acting on that intention since that rate proceeding. But through the course of it, we have exercised management discretion, and the pace has varied with changes in our operating environment, notably increases in gas leaks, which are not a prospective hazard, but really more of an imminent hazard.
So in acting on the company's intention, I think that those were your words. That intention, well, I ask, was that intention binding? Or was this something that Washington Gas, acting on its intention, could walk away if and when it saw fit?
From the perspective of what's required or allowed under the regulatory framework or the legal framework, I'm not your best witness there. But I can say Washington Gas would never, knowingly fail to meet something it understood as a commitment, or barring an ability to meet it, bring it for discussion.
So your testimony, again, I'm asking, you use the word commitment. Are you testifying that it was a commitment made by Washington Gas?
No, sir. I'm not trying to countermand anything Witness Reed just testified to.
And I'm not asking you to. I'm just trying to get your understanding as to what was the approach. You said it was not an agreement. You said it was not an obligation. You said it was not a commitment. I use the word promise. I use the word wish. I think you've testified that it was binding. And so I'm trying to get your characterization.
Objection, Your Honor. I disagree. I believe that was not the witness's characterization, that counsel has mischaracterized it in his question.
I thought I heard binding. If he didn't say binding.
Okay. Mr. Buckley, is your concern with the characterization that the term binding was used?
Yes, and in the way the question was asked, as if it was a binding commitment. And that was not the way I heard Mr. Murphy describe it.
Mr. Caldwell, if you'd like to just rephrase your question, ask it again. I don't recall if Mr. Murphy referred to it as binding or not. You could ask him that question.
Was the plan to replace all mercury service regulators, inside regulators in Maryland over a 10-year period? Was that binding on the company?
Again, if you're asking from a rate making or legal perspective, I'm probably not the best witness to address, but my understanding is the company's position is it was not.
From a legal or rate making perspective, I'm asking your understanding as to whether or not that plan was binding on the company.
Mr. Caldwell, he said no.
Okay. I'll move on. Mr. Murphy, the commission refers to Washington Gas's stated commitment. In several orders, they talk about the company's stated commitment. Is the commitment incorrect in that characterization?
I can't. I'm not in a great position to speak to what the commission meant by commitment. Again, my view is if the company committed to anything, it was in good faith. We laid out a plan, and we acted on it. And so if our commitment was to act on the plan, which again, like so many of these programs, it is a plan. We operate in a complex environment. Things change. The plan is also based on estimates. So if the commitment was to within the confines of providing safe and reliable service and using management discretion to do so, but to act on the plan, we obviously acted on the plan. So depending on what the commission is looking to us, and what a commitment it's ascribing to us, if it's ascribing that we made a commitment to act on the plan, act on the words we used, I feel we did that and continue to do that.
Okay. Thank you. Page 6, lines 14 through 18 of your testimony. Are you there?
Yes.
You note that to be or understood to be the type of regulatory commitment that flows from a regulatory requirement. Do you see that?
Yes, I see that.
Is it your testimony that a fine or penalty is proper only when there's a violation of a regulatory commitment that flows from a regulatory requirement?
That might call for some legal judgment. I don't know. I would assume that if the commission finds us to be imprudent, there is a framework in place for the commission to fine us for poor judgment. But to the extent I need to know more about the law than I do, that's the best I can do for an answer.
Well, I'm not asking you to act as a lawyer. You're ably represented by Mr. Buckley. I'm sorry. Your testimony, and my question is it your testimony is it your testimony that a fine or penalty is proper only when there's a violation of a regulatory commitment that flows from a regulatory requirement? I'm using your words.
My words don't describe a fine. My words say we did not understand it to be the type of commitment that flows from, DOT 192 or COMAR or an order.
Okay, well, I'm sorry, I didn't mean to cut you off.
That was it. I just don't see a reference to a fine there.
Well, I'm asking.
And again, I'm sure there's a framework in place for the commission to fine us for failing to meet our obligations. I don't, is that beyond 192 or Comar? I don't know.
Page 26, lines 13 through 15 of your testimony. You turn that page, please.
26.
Yes.
13 through 16.
Yes. 13 through.
Okay.
Okay, there you state that for a fine or for a penalty or fine to be assessed, there had to have been a violation of a governing statute, regulation, or order. Is that correct?
Yes.
Okay. So assuming as they did that the commission recognized or granted rate recognition to the replacement plan, failure to complete the plan would be a violation of a
Objection beyond the scope of this witness testimony. That would be better addressed at Mr. Tornimi, who addresses rate issues.
Honor, if I might respond.
I'll let you respond. Yes, Mr. Caldwell.
I'm quoting his testimony, Your Honor. At page 28, lines 13 through 16, he says, for a penalty or fine to be assessed, there had to have been a violation of a governing statute, regulation, or order.
And state your question again, Mr. Caldwell.
Well, assuming that the commission approved rate recognition of the replacement plan, failure to complete the plan would be a violation of a commission order, wouldn't it?
And again, Your Honor, if I may, if I can be heard, that the very next sentence in Mr. Murphy's testimony kicks that very same rate making question to Mr. Reeds and Tornimi. The question is one of rate making, whether or not there's a obligation that flows from rate making of commission approval of specific rates.
I'm going to sustain the objection here. Yes, Mr. Caldwell, you could save that question for Mr. Tormini. Mr. Murphy here does provide his opinion on the penalty, but as Mr. Buckley just noted, in the very next sentence, the rate-making experts are Mr. Reed and Mr. Tormini. So let's move on.
Thank you, Your Honor. Just a couple more questions, Mr. Murphy. At page 29, lines 1 and 2 of your testimony, is it your testimony that the company believed in good faith that the annual reporting requirement no longer existed?
I don't think the company, looking back a good portion of these 17 years, understands exactly the circumstances that led to the discontinuation of the report. As I've laid it out, it was either because we believed it was no longer required, that because the subsequent rate proceeding didn't carry that forward, and the subsequent request for a cost of service adjustment didn't reference it, that it was superseded, or again, the other possibility was it was an oversight. In either case, we recognize that it should have continued, or if we intended it for it not to continue, there should have been communications around that.
Final question, Mr. Murphy, if you would turn to your rebuttal testimony on page 4.
Yes, sir.
There you state at line 19, I'm sorry, the MSR replacement initiative was a voluntary program. Do you see that?
I do see that.
When did the replacement program cease to be voluntary?
It is my understanding that the program has always been executed within the rates established as part of management's discretion. And what I'm discussing right here is a statement that says we came in requesting authority to initiate the program, and we did not do that. We would not have done that because we have the authority to take actions like that. We don't have to come in and ask permission. We felt we needed some cost relief, but we did not need permission to go out and begin replacing those regulators. And in fact, in other jurisdictions where we have the same regulators and we made the same request for relief, it was denied, and we continue to replace the regulators in any event. And another example of that is further discussed in my direct testimony when leaks in Prince George's County escalated dramatically. We didn't hesitate to put resources where the need was. We didn't seek permission or rate relief first. We took action and worked to resolve the issue. And those actions, as these are subject to after the fact review by the commission. And I suppose that's why we're here.
So is your testimony the program is still voluntary?
Voluntary in the sense that it is still in at this moment in time subject to management discretion. We have put a plan in front of the commission, and I have no doubt that we will come away from this proceeding with absolutely clear rules regarding the execution of that program going forward, and notably robust reporting, which I think is important, and it gives the commission that framework to monitor prudent decision making.
So if the program continues to be voluntary, is it your testimony that the company can stop replacing meters whenever it wants to? I'm sorry, I said replacing regulators.
I'm not aware of a regulation or a law that would require us to do it, but we would be subject to a prudency assessment if we decided to do that. And as I sit here, I couldn't come up with a good justification that would say it would be prudent to stop. So we couldn't do it in ignoring excuse me, my books fell over, and ignore our service obligation, franchise obligation for safe and reliable service. Pardon me 1 second. Thank you.
Okay, well, Mr. Murphy, I'll try it one more time. Your testimony is that the program is currently voluntary. Is that correct?
In the sense that it is still, to my understanding, subject to management prerogative and discretion. In terms and how much we do and how quickly we do it. That is my understanding.
Okay, and because it's voluntary, you could stop replacing regulators anytime you wanted to.
We cannot ignore our franchise obligation for safe and reliable service and prudent decision making. So I don't think that second statement is true.
It's not really voluntary then, is it?
In that sense, no.
Okay. Is it voluntary in the sense that the company continues to collect costs in rates for this program?
I would again refer you back to witness Reader Turanimi. The argument I heard this morning, and again, I'm no expert, but rates are set, and management uses its judgment in providing safe, reliable service thereafter.
Thank you, Mr. Murphy. Your Honor, I have no other questions. I would like, Your Honor, to introduce into the record the two data requests that were referenced, but given your admonishment this morning about not using data requests to put in the record, I'd seek some guidance if that would be acceptable.
Well, I see that these two exhibits are fair game. They were both authored by witness Murphy, AOBA exhibits number 3 and 4. So I have no objection. You did question the witness. Do any parties have objection? Seeing none, AOBA exhibits number 3 and 4 are moved into evidence.
Thank you, Your Honor.
Mr. Cleaver.
Your Honor. Good afternoon, Mr. Murphy. My name is Joe Cleaver. I'm from the Office of People's Counsel. Nice to see you.
Good afternoon, Mr. Cleaver.
If I could begin by asking you to look at page 11 of your direct testimony. And you can tell me when you're there. I'll tell you the.
I'm on page 11.
Okay, and the line I wanted to ask you about is line, the portion I wanted to ask you about starts at line 20. There's a question here that says, did the company testimony in case number 8959, and just again for the record, that is of the two old rate cases we're talking about, that is the second one, the one that was filed in 2003, correct?
Correct.
Okay. Did the company testimony in case number 8959 include any references to the MSR replacement discussions in case number 8920, which was the earlier case filed in 2002 that ended in the stipulation and settlement, correct?
Yes.
Okay. And the answer is, with me a second. The answer is, you say no. To the contrary, the testimony presented by company witness Rana in support of the cost of service adjustment described the MSR replacement program just as company witness Cook did in 8920. It included a brief description of why the company had embarked on the proactive replacements and suggested that utilizing a 10-year period for the program would be reasonable as the basis to calculate the annual expense level in support of the cost of service adjustment, not the remaining 9 years of the MSR replacement discussed in case number 8920. No other parties pre-filed testimony or the commission order in case number 8959 referenced the MSR resolution in case number 8920, which was just 1 year prior. Do you see that?
I apologize. I was actually on the wrong. I was on my rebuttal. You're on my direct at what page?
Okay. Well, instead of reading it again, let me ask you to just read the question that begins in your direct testimony on line 20, page 11, line 20,
11.
and then and the answer continues on page 12, and the answer's at lines 1 to 10. Why don't you take a look at that and tell me after you've had a chance to read that?
I've got it. Thank you.
Okay. Are you ready for me to move on, or are you still reviewing?
You can move on.
Okay, and then let me ask you about one more excerpt, and then I'll ask you a couple questions. Next, if I could ask you to go to page 28, also of your direct testimony.
Okay, I'm there.
When you're there.
I'm there.
And you explain, I'm looking at starting at line 5. Actually, let me start at line 4. You say the company commitment to submit reports was made in case number 8920, 2002. While the subsequent rate case number 8959 was pending, Washington Gas submitted a report in compliance with that commitment. Shortly thereafter, the commission issued order number 78757 in case number 8959. There's no language in the case number 8959 pre-filed testimony or commission order that suggests the MSR replacement program was a continuation of the program recognized in case number 8920 a year earlier. Therefore, it could be reasonable to conclude that the reporting commitment was fulfilled by the single report made before the conclusion of case number 8959. Just a couple questions for you on that, just to make sure I understand exactly what you're getting at. You say it could be reasonable to conclude. First of all, again, I'm looking at page 28, line 5 of your direct, or actually, page 28, like I just read at line 11, when you say it could be reasonable to conclude that the reporting commitment was fulfilled by the single report made before case number 8959 concluded. Is that your opinion? You say it's reasonable to conclude that. Is that what you think? Is that the opinion you're offering?
I said it could be reasonable. I think ultimately the recommendation that I made was go to the following base rate proceeding when there is no mention of any MSR replacement program or adjustment, and that is the point where it would be ultimately reasonable that we had subsumed those activities into normal operational activities and management prioritization. There was no request for a cost of service adjustment. We just presented our costs as they were in the test year. Certainly no mention of further reporting, and that's probably the better point at which to assume any special treatment had ended, and thereby the reporting with it.
In preparation for your testimony in this case, have you reviewed the commission's orders in these two rate cases that I've been asking you about, that you talk about in your testimony, 8920 and 8959?
I've reviewed the relevant portion of the stipulation agreement and revised stipulation agreement in 8920, and I've reviewed. Yes, I have portions of the 8959.
Okay, let me ask you this. Are you aware that the commission's final order in case number 8920 approving the stipulation was dated September 27th, 2002?
I'm not sure I was aware of that, but subject to check, you're probably right.
Okay, you'd accept that subject to check?
Yes.
Okay. And were you also aware that case number 8959 was filed on March 28th, 2003, just 6 months later after the final order in 8920? Are you aware of that, or would you accept it subject to check?
I could accept it subject to check.
And at the time that case number 8959 was filed, and the application with an application that included the company's direct testimony, the first annual report flowing from the 8920 settlement, that wasn't due yet, correct?
That sounds reasonable, yeah.
Yeah. And in fact, that 8920, the one report that was filed, that was not filed until October 20th, 2003. Are you aware of that?
Subject to check. I don't know the date off the top of my head.
Okay, thank you. And would you also accept subject to check that at the time that all the parties filed their testimony in case number 8959, that the report, the first report due from the 8920 settlement, it hadn't been filed yet, and it wasn't overdue at that time. Would you accept that subject to check?
I would.
Okay, thank you. Let me ask you then, what is the significance of the fact that you mentioned this a couple times in your testimony in the excerpts you and I just went over when we began? Again, I'm just trying to probe this a bit more. What is the significance of the fact that you say this a couple times, that when the Mercury Service Regulator Replacement Program was discussed in 8959, it wasn't mentioned as that there were 9 years left, but rather it was mentioned as a 10-year program. What inference are you drawing, or what point are you making by bringing that point up?
That it was not, at its face, a continuation of a program that parties are interpreting was submitted and approved in the prior case. In the testimony of witness Rana, it just lays it out in the very same way witness Cook does, which I think points to the company's basis for providing it, and understanding that what we were providing was a basis for a cost of service adjustment. You needed that information if you were going to develop a cost of service adjustment. So it was laid out as a 10-year plan, perfectly reasonable, because I in my opinion, that the estimates of the number of regulators weren't precise enough for the intervening activities of 1 year to have mattered very much. But it was what was put into testimony was sufficient to support the cost of service adjustment.
Okay, let me refer you to what's been pre-marked and provided to the commission and shared with the parties as OPC Exhibit 9. Do you have access to that, sir?
Is that OPC data request 1, question 21?
That's correct.
Yes, I have it.
Okay, this, as I mentioned, this has been marked as OPC Exhibit 9 in this case, but this is a data request from case number 8959, the 2003, the second rate case of the two older cases we've been discussing. And it's OPC data request 121. And as you can see, the response is dated here May 1st, 2003. So the question asks, why was the actual per book operation and maintenance expense for 2002 only $52,464, given the annual level of expense for the mercury regulator's changeout expense presented in case number 8920? And the answer is the level of expenses are lower because the program was not fully implemented until late fall of 2002. And at that time, it was phased in until full crews could be hired to execute the work plan. Refer to witness Rana testimony, pages 13 to 14. The company is on schedule for the mercury regulator changeouts program to be fully implemented by spring, summer 2003. Have you ever seen this data response before?
I don't believe I have.
Okay. Does this data response change the answer you gave to my question of a minute ago about the significance of the fact that the company didn't describe this as a 9-year program, but rather described it in the second case as a 10-year program when I asked you about your discussion of that point?
Not really.
Well, if I remember your answer correctly, I think that you said something along the lines of, and I don't have the live feed to the transcript, but I believe that you said that to you, it called into question whether we were talking about the same program. And this data response asks about the expense level in 8920 and then explains that the program in question here, it explains why there was a delay and it wasn't implemented. And actually, as of the date of this response, May 103, it hadn't been fully implemented yet. So does that change your understanding of the fact that your company's witnesses said 10 years in the 2003 case as opposed to 9?
Not particularly. I mean, if the company, I really don't have the context for some of these details from back in 2002 and 2003. But if the company presumably knew how many regulators it replaced, knew how much had been spent, it would have at least, if it viewed it as a continuation of the plan, would have reduced the total by some number. But it didn't. It just almost exactly the same support for a cost of service adjustment was made from 1 year to the next, because ostensibly for the same reasons, which this seems to support, that the test year cost of service really wasn't reflective of where we felt we would be going forward.
You would agree that this data response indicates that the mercury service replacement program discussed in case number 8920, the first of the two cases, wouldn't be fully implemented until spring, summer 2003, when the second of the cases, 8959, was pending.
This DR does talk about it as the program.
Okay, thank you. And just on that point, one more exhibit, if I could refer you to what's been pre-marked as OPC Exhibit 7, which is as I think I mentioned earlier, the one report that was filed pursuant to the 8920 settlement. dated October 20th, 2003. Let me know if you're there.
I'm there.
Okay, so again, this is the report filed, and it says here, WG Mercury Regulator Replacement Program Annual Status Report required by Maryland PSC, in parentheses, item 11 of the stipulation in case number 8920 phase 1. Do you see that?
Yes.
So this report, would you accept subject to check, or do you know that this report was filed in the 8920 docket, not the 8959? Would you accept that subject to check?
Subject to check, yeah.
Okay. And it provides, as it says, it provides the status of the replacement program based on data from October 02 to August 03. And then in the first bullet point, it talks about the reduction in the estimated number of mercury regulators as provided in case number 8959. You see that?
I do.
So this report that Washington Gas filed in the 8920 docket, it indicates that the numbers that Mr. Rana was talking about in the second case, 8959, the 2003, that was the same program as what had been discussed in the settlement of 8920. Would you agree with that?
Could you restate that one time?
Sure, I can reframe the question. This report filed in the 8920 docket pursuant to the 8920 settlement indicates that the estimated number of MSRs at issue had changed, and explains that change in the estimate was explained in case number 8959.
I do.
You see that?
I see the cross-reference in the document, yes.
Right. So this document lends further support to the Mercury Service Regulator Replacement Program that was discussed in 8959 was the same program that had been the subject of the settlement in 8920. Correct?
Again, and my recommendation relative to a penalty associated with reporting, I think is consistent with that, and suggests that calculation should consider out to the next rate case, which I don't recall the number off the top of my head.
Yeah, all I'm asking you, sir, is this document here, would you agree that it indicates that the Mercury Service Regulator Replacement Program that was discussed in 8920 and that was discussed at the hearing on the stipulation and referenced in the settlement, this document supports that it was the same program that was discussed in 8959. Would you agree with that?
Again, it's the same activity. It's this, however we want to package it. It's the same activity that we discussed in 8920 and 8959 and sought an adjustment for.
Thank you. Let's see. If I could ask you to turn to page 16 of your direct testimony.
I'm there.
And bear with me, I thought I was there. Okay. Yeah. Specifically, sir, I wanted to ask you about this chart 1 that you have here on page 16 of your direct testimony. Are you there?
Yes, I am.
Yeah. And as I understand your testimony, and one of the company's theories of this case is that the Mercury Service Regulator replacement activities were decreased in fiscal year 2005 and fiscal year 2006 because the company reprioritized the work in light of a an unexpected increase in leaks in Prince George's County. Is that right?
Yes.
And this chart, as I understand your chart here, is intended to show that there's a correlation between a decrease in those mercury regulator units replaced, which is the orange line, and the increase in the Prince George's County coupling leaks, which are the blue bars for each fiscal year. Is that fair to say?
I think that's fair.
Okay. And as I look at this chart, it looks like, starting in fiscal year 2007, and then even more so in fiscal year 2008, it looks like the company was on its way to getting those leaks under control. Would you agree with that characterization?
Relative to the peak years, yes, leaks were beginning to be controlled.
Yeah, fair enough. And in those 2 years, specifically, most notably in fiscal year 2008, the level of mercury regulator units replaced went up significantly from the fiscal year 2007, right?
Appears to be the trend.
Yep. And something that Mr. Reed mentioned this morning made me want to ask you about this. There's fiscal year 2008, it goes from it's July 1st, 2007 to June 30th, 2008, right? That's fiscal year 2008?
No.
Tell me what your fiscal year is.
It's October 1 to September 30.
Okay, so this fiscal year 2008 is the period ending September 30th, 2008, right?
Yes.
Okay. I think everyone at this point is well aware that the company disputes that there was a commitment to replace mercury service regulators within 10 years. There's been a lot of discussion about that in this hearing. But just let's, understanding that that's the company's position on whether there was a commitment to do that, let's just stick with that 10-year time frame from the final order approving the stipulation in 8920. So as we talked about earlier, that date was September 27th, 2002. And would you agree that 10 years from September 27th, 2002 is September 27th, 2012?
Yes.
Yeah. So in this period ending September 30th, 2008, as you agreed, relative to the peak of this leak problem, the company was on its way to getting these leaks under control. And that would have left 4 years, almost to the date, 4 years from the end of that until you reach the end of that 10-year period ending September 27th, 2012. Do you agree with that?
Your calculation seems to be accurate.
Thank you. And Mr. Reed this morning made a comment that if there were a few years of slippage, then it would make it difficult for the company to complete the mercury regulator replacements within that 10-year period. Do you recall hearing him say that?
I think one thing you have to remember is it's pretty easy to spot these things in hindsight. It's not quite as easy in the moment as operations are developing and as leak results are coming in. So if the suggestion is we should have known there would be a dip, then we'd have an opportunity to reaccelerate these efforts. I think that's easier to spot in hindsight than in reality. Again, management is using judgment throughout this. I would remind folks that mercury regulators are a prospective hazard that it's our experience that they are not a pipeline safety hazard. There is a amount of mercury in them that represents an environmental hazard, and they should be removed from the system on that basis, but they don't behave differently than other regulators, and we were safely managing their existence and continued operation throughout that period. So, I wouldn't say that we can look back and see a lull and say we should have ramped back up there. And I think we also have to keep in mind the context that relative to all the things that were going on in our environment, they remained a relatively lower pipeline safety risk.
Thank you. Let me ask you this question. Based on what you know today, is it your understanding that? Let me strike that. The company has cited the issues in Prince George's County that are reflected in this chart as at least one reason, and I would say based on the amount of airtime it gets, the primary reason for why the company reprioritized its work in this case. Is it your opinion that those couple of really bad years, as reflected by these tall blue bars on this chart, made it impossible for the company to catch up from this, say, fiscal year 08 or fiscal year 09 to the end of 2012? Or is it your testimony that there was some other intervening, unforeseen, dangerous development that came after this Prince George's County issue that prevented the company from completing these mercury replacements by the end of 2012?
So I think two things happened during that period. One, we found ourselves in possession of a much better framework for assessing and prioritizing operational risks and our response to them. And that's the DIMP program, which came into being after much collaboration between PHMSA and industry in 2011. And service regulators have been part of the DIMP program, and they, from its inception, have never arisen or even begun to compare with the ranking of risks of our top items, which would include coupled piping. So that intelligence, that business intelligence that came out of that well-conceived program, that happened during that period. And then, as discussed later in my testimony, leaks did begin to scale back up. And so now we have the DIMP plan as a compass to help us steer by, and it's not indicating that additional resources or attention is required. And we have, again, a continued complex changing operating environment. So I don't think it's reasonable to look back and conclude that we should have done anything differently. We operated with the best information we had at the time. We improved our processes throughout the period. As I said before, we did not believe we were operating under a commitment or a deadline to get the work done by a certain date, by a date certain, and we behaved that way. And we exercised prudent management discretion throughout.
So from the period of fiscal year 2008, as shown on this chart, and the completion of the DIMP plan in 2011, are there any other intervening events in that 3-year period that the company contends prevented it from ramping up the mercury regulator replacements during that period and replacing them?
I don't have an exhaustive view of everything that was going on in our environment. My testimony tries to capture the major themes that occurred over this very long period of time. The reality is the company replacement numbers through that period are what they are. As I said before, they never stopped. The replacement continued throughout. and continues to this day.
But thank you. And just one more question on your DIMP. If I understood you correctly, in 2011, when the DIMP was completed and the new learnings about its own system and the relative risk of different parts of the system, your testimony is that the company in 2011 determined that there were other more pressing things in need of replacements other than mercury service regulators. Did I hear you correctly to say that?
Yeah, to my knowledge, the DIMP plan has never placed mercury service regulators or any service regulators near the top of the risk matrix.
Yeah, and I saw that in Mr. Reed's testimony, but are you aware of the company making a decision in the 2011 timeframe that, hey, we have this DIMP now, and based on what it's saying, we're going to do other things other than these mercury service regulator replacements?
The DIMP manual or the DIMP process did inform the company on where its priorities needed to lie and where its replacement efforts would be best spent. I'm not sure what I can describe beyond that.
Sure. I'm wrapping up here soon. I have one more exhibit to show you, but let me ask just one more question on that point. Again, understanding that the company's position on whether or not there was a commitment to replace the indoor mercury service regulators within a 10-year period. Do you recall during that 10-year period, most specifically after the worst part of the Prince George's County leak situation, that the company was aware that it had a mercury service regulator replacement program, but consciously made a decision to lower its priority based on other system needs that the company had determined were more important. Do you know that as you sit here based on your experience at the company?
I was not directly involved in establishing the amount of mercury regulator replacements that occurred during that period.
Okay, thank you. Bear with me. May I have the commission's indulgence for just a moment, Your Honor?
Yes, Mr. Claver.
Just looking for one more exhibit, and we'll be wrapping up quickly. And finally, Mr. Murphy, I want to ask you about one more document. I want to ask you about what's been marked as OPC Exhibit 13, which consists of a series of questions on that you sponsored, I think all but the first one, which was from Mr. Turnimi. It's the company's responses to OPC DR set 4.
For 1 through 4.7?
Correct, yes, sir.
I have them.
All right, I would like to ask you a quick question about question 4-4, which is on page 4 of the PDF. And tell me when you've had a chance to look at that.
Yeah, I see it.
And you sponsored the answer to this question, correct?
Yes.
And the question, and if you want to read more of it into the record, you can, but in the interest of time, the question asks if prior to the issuance of Commission Order number 89248 in this docket, which was the show cause order, in September 2019, was the company aware that its 10-year MSR replacement program, as described in the testimony of company witness Hardeep Rana in case number 8959, had not been completed? And you say a number of things, which if you feel they're necessary to read, you can, but I'll just refer you to the last sentence of the first paragraph of your answer. And you say, the company was aware that the intended plan of completing the MSR removal as outlined in case number 8959 was not realized prior to September 5th, 2019. So that just kind of following up on the last question I asked you when we were talking about the the company's awareness of the program, notwithstanding the company's position on the commitment, but just the company's general awareness on the program. You say here in this data response that the company was aware before the commission issued the show cause order, pointing out the situation with the program, that it hadn't been completed. Was there a point in time prior to September 5th, 2019, when the company became aware of it, or is it your understanding that the company was always aware that there was this program, but that it hadn't been completed?
I don't know of a specific point in time. Again, company, after the case, 4 years subsequent to 8959, the company's view was this was part of our normal operating activities. We can refer to it here in this DR as a program to the extent that is a shorthand for a number of regulators over a period of time. But it was clearly the company's operating understanding that any alternate treatment of costs or special lens through which the commission and others may have viewed this work was no longer in effect, because none of those treatments were relevant past that case 4 years after 8959. So I think the context is a little flawed. We were aware of the number of regulators we had replaced, and we were aware of the numbers that were stated in 89-20-59.
Okay, thank you. One final question, just for the record, and recognizing before, in anticipation of a potential objection, I'm not going to go far with this, and this is my last question or two. If I could take you down two pages to the response to OPCDR 46. This is to take a look at this data request and the company's response, and let me know when you've had a chance to look at it, and then I just have a quick question for you.
Okay, there.
Yeah, and this was OPC data request 46 to the company in this docket 9622, to which the company responded on August 18th, 2020. Do you see that?
Yes.
And you were the sponsor of this answer?
Yes, I was.
Yes. And subpart A to the question asks whether the company still contends that the Flower Branch accident was caused by a sequence of events which remain unknown to this day. And the answer is yes, correct?
Objection, Your Honor. I'm objecting to the line of questionings related to the data request. In particular, I'm objecting and ask that stricken that the answers are being read and into the record even in advance of the questions. The commission has previously ruled that the cause of the incident, the Flower Branch incident, was not an issue to be explored in this hearing. And that's exactly what this data request and the references counsel for OPC has made.
Objection is sustained. It is outside the scope of the April 29th order.
Very well. Thank you, Your Honor. Mr. Murphy, thank you, Your Honor. I don't have any further questions. For purposes of moving exhibits in, Your Honor, I mean, based on the colloquy from before with the documents from 8920, I could just wait to, see what the company puts in and then address that later. Or there's a couple here that I could put in or now, if the commission would prefer that.
You used a few now. If you want to put those in, particularly those sponsored by Mr. Murphy, and I think you used exhibit number 7, which was the 8920 report, the one-page report.
Okay. Yeah, I would ask for entry of into the evidentiary record of what's been marked as OPC Exhibit 7, which is the one annual status report that was filed in case number 8920.
So marked.
And as well, Your Honor, OPC Exhibit 9, which is the company's response to a data request from the 2003 base rate case 8959. The response to OPCDR 121.
Yes, dated May 1st, 2003, so marked exhibit number 9.
And then, Your Honor, for exhibit 13, I included a number of responses. When I put my exhibit list together, I was still preparing cross outline, and I ended up, of course, only using two, but in light of the sustained objection, I really only have one to put in. So I could just move for entry of admission of the one response, which is the response to 4.4. And I would just ask, I don't believe I don't plan to enter any more from this set. If I could confirm that for a second. Yes, I don't plan to enter any more data requests that are in the package marked as OPC Exhibit 13. So I would just ask that the company's response to OPC data request 4.4 that Mr. Murphy sponsored and answered questions on, I would ask that just that alone be entered as OPC Exhibit 13.
No objections, Your Honor.
Thank you. OPC Exhibit number 13 in its entirety will now just contain the one data request and response for number 4.4 dated August 18th, 2020, and is moved into evidence.
And Your Honor, just to clarify, I would move for entry of OPC Exhibits 7 and 9 as well. Have they been moved in?
I believe I just moved them in, but if I did not, OPC Exhibits 7 and 9 are moved into evidence.
Okay. Thank you, Your Honor.
Thank you. Cross-examination by Mr. Dean.
Good afternoon, Mr. Murphy. I'm going to keep my video off because I have a low bandwidth connection here.
Good afternoon, Mr. Lee.
Thank you. I just have a few questions. Turning to page 6 of your direct testimony, at lines 20 and 21, you describe your replacement program as a proactive plan, a reasonably managed proactive plan to replace its mercury service regulators. Could you describe all the ways that you believe that it's been reasonably managed and proactive?
It was proactive because it was a program that we identified and proposed and took steps to implement before approaching commission for consideration of a cost of service adjustment, and likewise in our other parts of our service territory in the District of Columbia, proactive in that there was no special adjustment associated with it, and we proceeded with the work. prudent, reasonably managed and prudent because, subject to the other.
Your Honor, if I might inquire through the bench, maybe Mr. Dean is shuffling papers.
Dean?
Oh, I'm sorry. I'm sorry.
You have a particularly sensitive microphone, so perhaps when the witness is answering your question, you could turn yours off.
I was about to address the reasonably managed portion, and that's just to say that we never ceased the work. The pace of the work was affected as other things happened, and management exercised its judgment, but it was reasonable given the other things that were occurring, and reasonable because we never failed to recognize it was important and never stopped.
Thank you very much. Turning to page 12 of your direct testimony. At lines 24 and 25, you state that specially trained crews remove and replace the mercury service regulators. Could you describe the process of replacing one of these regulators, and also note any differences between the process for indoors or outdoors regulators?
I can do it only at a very, very high level. It's possible witness Jackson may have a little more familiarity, but the specific variances to what you would do with a normal regulator is you're going to bring in an instrument to take mercury vapor readings and make sure there's no escaped mercury, and you will put down and take spill prevention precautions to make sure that as the equipment is being extracted from the meter buildup, should any of the mercury escape, it's contained and can be cleaned up, and then the regulator itself has to be properly secured inside a container so that it can be safely transported without the risk of any release of mercury during transport. So at a very high level, that's what makes the handling of mercury regulators a little different in the course of a replacement project as compared to a standard regulator.
Thank you. Turning to page 28, of your direct testimony at lines 11 through 13, were you here, or were you listening, I should say, when Mr. Reed was being cross-examined today?
I was.
Is it still your testimony that it could be reasonable to conclude that the reporting commitment was fulfilled by a single report made?
It could be reasonable. I recognize it's not Mr. Reed's position, and honestly, it's not the conclusion I reach. But if we are going by the specific language in a settlement or an order, it was there in 8920. It's not there in 8959. I recognize that special treatment continued on in 8959 and beyond for at least 4 years, which is why I arrived at the penalty that I did later in my testimony.
Thank you very much. At lines 1 second, please. on page 29 through 30, at the bottom of 29, you state that you indicate that it would be reasonable to expect that reports would be submitted until the next base rate case was filed 4 years after the conclusion of the other rate case. Was the value of 4 years determined by you or based upon advice of counsel, as suggested at line 15?
I did have the benefit of advice of counsel as to the effect of the subsequent case.
Thank you. Do you have a reason why reports should not be filed until the end of the removal of mercury service regulators completely from Washington Gas's system?
Again, the company's thinking there is that the reporting requirement accompanied any special consideration given to cost of service treatment associated with those activities, which stopped 4 years after 8959, and we essentially reverted to a traditional approach to both management using its full discretion in assessing when, how many, and so on, these regulators to remove, and a traditional approach in terms of how those costs were collected and flowed through rates. So that's as opposed to what I believe the other parties are keyed in on, the original intended plan, which was 10 years. And again, the company's intended plan did change with conditions in its operating environment and with ongoing operating insights that are collected.
Thank you very much. I have no further questions. Thank you.
Thank you, Mr. Dean. Mr. Buckley, do you have any redirect for this witness?
Just one moment, Your Honor, please. Just check notes. Just one matter, Your Honor. Mr. Murphy, and I'm not even certain you know the answer to the question, but do you recall the questioning for Mr. Cleaver related to the implementation of the DIMP plan in 2011?
Generally, yes.
And during that discussion, you also indicated that there was a collaborative engagement with PHMSA and others to produce that DIMP plan. Do you recall roughly how long that collaborative discussions may have taken before the DIMP plan was completed, filed, and then approved?
I recall it was on the order of 2008 when the process for developing the proposed regulation really began.
Thank you, Your Honor. That's all I have.
Thank you. Questions from the commissioners, beginning with Commissioner Richard.
Great. Thank you, Mr. Chairman. For some reason, my computer kept muting me back. So anyway, good afternoon, Mr. Murphy. Thank you. Again, I want to just, looking at section 13.204, the civil penalties, should we decide a penalty is warranted, it also gives us some guidance as to what we should base it on. And one of the items in D, section D, is the gravity of the current violation. So I just wanted to just understand a little more about the regulators, the mercury service regulators. It's my understanding, if I'm reading the testimony correctly, The reason for the program proposed in 2002 is one, because of the mercury, the safety aspects of the mercury, and also the age. Is that correct? That those were both of concern to the company, and so therefore are the driving reasons for proposing the program in the first place, the accelerated program?
Both those factors were cited, the primary being the mercury. I would add, particularly in the context of the DEMP program, these regulators don't seem to be aging any differently at all as compared to other regulators on our system.
Okay. So in 2002, there was a concern that they were already, many of these out there were 40 to 60 years old. So could you just tell me, as you know, not a basic understanding, I looked it up, how these things work, but why was there a concern about the mercury in these units, and how they might cause mercury poisoning, and did age have a factor behind that concern?
That's a good question. Age really does not have a factor with respect to the device's ability to contain the mercury. Really, by far the predominant and nearly exclusive way mercury gets out of these devices is when someone who is not properly trained, not following Washington Gas's protocol, interacts with it. So if a plumber interrupts service and then quickly restores service, the regulator might not react quickly enough. The overpressure protection triggers, and the mercury can be essentially blown out of the regulator through the vent. The other instance that can happen is, unauthorized modification of our piping systems. People are remodeling or what have you, and they take it upon themselves to try and relocate or modify our equipment and don't handle it properly, and then the mercury can get out. It's not an issue of the regulators under normal operating conditions, under expected operating conditions. There's really not an avenue for the mercury to get out.
Okay. And then as far as what are the consequences of failure of a service regulator?
So service regulators have been in use in the industry for many, many years, and they include the design consideration where they have built-in overpressure protection. So if the main sealing surface should fail to completely stop the flow of gas and pressure builds up on the downstream system, the relieving element releases that pressure, so pressure doesn't build. A small release of gas is created, and an odor is readily detectable, and we come out for a service visit.
Okay, so a gas leak would be a consequence of failure then, and hopefully someone would smell the fact that there's something leaking.
Yeah, in terms of, I would distinguish it from a gas leak on, say, an underground piping system, because these vents are piped to a safe location.
Okay. Would age have anything to do with a potential failure? In other words, a 40 to 60-year-old service meter, would you have any concerns? Is that one of the reasons that specifically in the program design, you said it's because of age and mercury and the sensitivity to mercury? So is it because of concern about failure of an old meter?
Again, they fail in such a manageable fashion with a small release of gas and a readily detectable odor that causes a service visit, that any aging of the seat and the orifice really has never been enough in the context of a mercury regulator or other regulators on our system to drive significant proactive replacement efforts. We simply go out and deal with them as they reveal issues.
Okay, so you're saying that a new meter service regulator and a very old one, a 40 to 60-year-old. Of course, that was 2002. They were 40 to 60-year-old. You don't have any particular concern about the age and the possibility of failure.
Not as opposed to another regulator of a different design in the same vintage.
Okay. And I want to be careful here because there's some, I guess, some sensitive information, confidential information in Mr. Jackson's testimony. But just to characterize, at one point, there was no reason, I guess, to have the MSRs in as part of the DIMP. But then later it's described recently. And I'm getting interested to know when recently. And do you know what I'm talking about? Do I need to refer to the testimony? But it said recently that there was a DIMP, reconsideration because it's required that occasionally you improve and analyze the DIMP, and that MSRs are being considered now as part of the DIMP.
As a separate category identifiable from the other body of regulators, yes. Okay,
so there was a change in thinking that MSRs didn't need to be in the DIMP, and now they are. And as part of an analysis and improvement in the DIMP. So I just, and again, I want to be careful because there was a matrix shown, and while MSRs weren't considered, most risky, they were also not at the bottom. They were somewhere in the middle. That's not saying too much, I hope.
And I have to interrupt at this point, Commissioner, we can't disclose where those MSRs were on the matrix. That's confidential.
Okay, I thought that there was a line early on that indicated something about relevance of this matrix and anyway, I'll stop there. But there seemed to be a concern that these MSRs needed to be in the DIMP. Is that true?
I'm not intimately familiar with the sequence that got them separated out as their own identifiable candidate category. It is conceivable to me that it was a result of sensitivities displayed by the commission and other stakeholders.
Okay.
Now, I'm not aware that it arose. The other way that these potential threats get identified is through a process where we involve our subject matter experts and the people who do the work. If they, in the course of fulfilling their responsibilities, become aware of trends, come to understand that there are threats out there, that is a critical inflow of information to inform the DIMP process. And I am confident that it did not arise through our subject matter expert channel.
Okay, just trying to understand whether the level of gravity of not completing the program within 10 years. So in 2005, there was a concern that there was now a competing and even more difficult problem, and that was the gas leaks, a couple leaks in Prince George's County. Did that, kind of maybe an analogy of like two houses on fire for a fire department. You still need to take care of, I guess, the problem that has been identified and has been, you described a moment ago as, never failed to realize the importance of this program, and putting it aside to go at the new, bigger program. Should the company have come up with a plan to try to figure out how to do both, or at least understand that they needed to, once the more critical problem was taken care of, that they needed to get right back on making sure this other realized problem was pending?
So I think the company always realized it needed to do both, as indicated by the fact that it never stopped. If you're going to use the analogy of, issues with a home, I think it's more like comparing the issues in Prince George's to, really manageable and infrequent issues we have associated with mercury regulators is like a home that's got a leaking faucet and the roof's blown off, and you're trying to figure out, where your attention needs to go. The Prince George's County experience was absolutely all-consuming. Critical safety concerns. We, as it developed and we were figuring out the drivers, we didn't know if every coupling on the system was going to leak. So it got full and complete attention. And notwithstanding that, to the extent we could muster resources to continue the program, we did.
Okay. And please don't get me wrong. I think what you did with the Prince George's County issues is exactly was reasonable, was prudent, and I don't mean to minimize the importance of the company taking on that problem. I was just trying to, again, understand what the issues were, what the dangers were with not continuing the 10-year program that you had identified, the company identified in 2002, and then it seems to kind of fall off the radar. I understand it continued, but it's not done today, and it doesn't seem like there was any thought given that you had a horizon, a time horizon, whereas at one point there was a critical period of time and had to get done, and then it seemed like after the 2005 pivot to a more important, a more dangerous situation, you didn't pivot back to taking care of this other issue that the company had identified.
Witness should wait for a question.
Is that true?
In 2002, my understanding is there was a recognition of kind of the pace, absent a program with some special attention, the pace that unadjusted that we would proceed on to get those mercury regulators out of service, and it was a long horizon, and it wasn't an assessment of unmanageable operational risk, because from before through 2002 straight to the present, our conclusion is we can manage the risk with these programs, or excuse me, with these regulators for as long as it takes to get them out of service. They don't fail dramatically. They are easily managed in the course of normal operations in the same way another regulator would be, but they have the environmental hazard, and I think it's appropriate, and it was concluded back in 02 and 03, and it's still my opinion now that it's appropriate and in the public interest to get them out more quickly than they would otherwise come out of service if we just let them operate, and until they've aged out to the point where you get that little bit of seat gas passing through the seat, the safety releases it, and we respond to an odor call. It's appropriate to get them out in advance of how they would come out in the normal course of things.
Okay, well, thank you. And just one last, you talked a little bit about different ways of, actually now switching over to the discussion about the penalties for not reporting. You just a couple of times said that, people can have a reasonable different approach. Do you think it's a reasonable, the approaches that were forwarded by both the People's Council and staff regarding how you might calculate the penalties for not reporting, given that it's also reasonable that since the company hasn't completed the program, reporting should have continued and is not. So do you think it's reasonable that we would consider the staff and or the OPC approach?
I mean, I expect you will consider staff and OPC's input. I've shared a couple of times the company's position, and that is to the extent that there was any non-standard consideration given to these activities, that reporting should have considered and continued. And I'll tell you that, it's just not my experience that the company would have stopped doing something um, unless it felt it was no longer required or just a mistake was made. So um, by the time we get to 4 years past 89, 59, and there's no elevated concern with the regulators. The parties have come together now 2 more times since the original case, and there's no more non-standard treatment going forward. To me, that seems like the logical place to stop the timer.
Okay. Yeah, I agree. I don't dispute there was potentially a good faith issue there. Does the company now have, controls in place or processes in place to make sure that these types of directives from the commission aren't overlooked?
We do, both in our Office of General Counsel and in our Regulatory Affairs Group. They track reporting commitments, and people are on point to send out the nasty grams to make sure this information flows.
Very good. Thank you, Mr. Murphy, and thank you, Mr. Chairman.
Thank you, Commissioner O'Donnell.
Thank you, Mr. Chairman. Mr. Murphy, I can certainly appreciate why the company had to attend to emergent issues in Prince George's County. It was a set of issues that emerged that reached the very highest levels of state, county, and municipal governments in Maryland, in Prince George's County, and in the legislature in Annapolis, where I was. So I remember it vividly. And you probably made a decision to shift resources, significant resources, to the emergent issues. I'm not so sure anybody's questioning the veracity of doing such a thing, except you had competing orders. The company had competing orders to report and to carry out a program that was approved in rates. And you stopped doing that. And that reporting would have informed the commission going forward of the internal decisions of the company. So the reporting stoppage was key to this whole thing, part of the key to this whole thing, in my opinion. But once those resources started to free up, and look, Cove Point is in my district. It was an integral part of the commerce of my district in Lusby, Maryland, where I live, 3 miles from my home. We're well aware of what was going on with Cove Point, but we were also well aware in the legislature of what was going on with regard to understanding the toxicity of mercury, a completely change in the view of that toxicity. The legislature was very, very interested in mercury removal from the environment. And yet your explanation as to why the environmental hazard didn't cause you to redirect those resources back to the program that the company had committed to at the same level that existed before you redirected them and used your discretion, why that seems to be minimized from an environmental perspective. I can tell you at the same time this stuff was going on, the legislature was considering programs of reclaiming mercury switches out of automobiles that turned your hood light on or turned your trunk light on because they were an existential threat to the environment, much like these regulators could be. And yet it seems to be downplayed here. Why wouldn't the company direct those same resources that have shifted away back to the pre-emergent issue levels, back onto removing these mercury switches as you had committed to and promised to do in a 10-year period? You may have taken you 12 years, maybe it's taking you longer. I don't know. We can't forecast that. I can't forecast that. But why don't you shift the resources back to that problem?
I'm not sure I have a satisfactory answer for you, Commissioner. I would say that we are, by nature, a pipeline safety focused organization, and perhaps that influenced decision making.
Well, I would hope, and I think the company even acknowledges the importance of this by saying we're going to get in there and inventory and find out how many we got and get them out again, just like the same problem all over again. It's deja vu all over again, to quote my favorite baseball player, Yogi Berra. I don't understand why the obligation that you have for safe and reliable deliverance of service is any less important from an environmental perspective than it is from a system operational PHMSA perspective. I fail to understand why the company doesn't have a good answer for that, and I haven't had it explained to me yet. Could you comment on that?
You know, I've cited a couple of times our DIMP program, and I do recognize that it is predominantly a pipeline safety focused program. I honestly am not familiar enough to state confidently whether or to the extent to which environmental risks are considered in developing our risk matrix. I would say that this program is something we feel works well. It's been demonstrated to be a compliant way to identify and manage our risks through the course of 3 audits by the Pipeline Safety Division of the Public Service Commission. That is not to say it's perfect, and we will absolutely continue work on a continuous improvement basis, which is really part of the way that plan is expected to be administered.
Yeah, I find it less than satisfying as to why the company didn't shift resources back to an obligation it had in another existential environmental threat. So, and ended up arguably could have maybe, we don't know for sure, it's not dispositive, but maybe could have prevented a catastrophic incident from occurring in Silver Spring. That's all I have, Mr. Chairman. Thank you very much.
I now recognize Commissioner Linton.
Thank you, Mr. Chairman, and good afternoon, Mr. Murphy. Just have a couple of questions for you. I'll start on page 22 of your direct testimony. I'm on line 13. That's where the question starts. Here you're basically talking about situations where the company may have realigned their resources in order to maintain safe operations. And you note that there have been other instances as documented within the DIMP, but you didn't state what those other instances might have been. So are you, just to be clear, are you suggesting that the other instances were situations or from the DIMP, or is this something else altogether?
No, it's from the DIMP. The next Q&A continues and identifies that from its inception, the DIMP process has always identified coupled steel piping as a type of infrastructure that needed attention. So that's the next leap in the application of DIMP that
okay, well,
gave rise to accelerated replacement programs.
Okay, so right, so this is the I'll call it pre-stride type of time period where the company was looking to pursue a stride concept in Annapolis, or through our General Assembly, excuse me. Didn't happen the first time we tried it, but second time the General Assembly went forward with it. But at the same time, the DIMP was, it's my understanding, at least from your testimony, I think it's the next page. You note that the replacement of the MSRs was also included in the DIMP. Was that around the same period? Did I get that correct?
I think it was later than that, if I'm not mistaken.
So, okay, well, let me just ask it that way then. When were MSRs added to your DIMP?
Commissioner, that may be in a DR. I'm not sure, and I cannot call that directly to mind. I think it was reasonably recently.
So then the audits that the commission conducted in 2011 and 2015, the replacement of MSRs would not have been an item that the commission would have looked at that time.
They would have seen an assessment of service regulator related risks, and MSRs would have been a subset of that, but not distinguishable in the design at that time.
Okay, so all right. So when the company was handling the leak issue happening in Prince George's County, the decision was made, of course, to reallocate some resources from the MSR program, using the company's language, the program, to basically to work on making sure that the system was safe and that the leaks were stopped. Were there other programs that the company had pending at the time that were also slowed down or ceased so that the company could proceed with making the system safe as a result of leaks? And I'll just tell you part B to that question. If so, give me some examples.
Yeah, I'm not sure I can identify another one. Just to speak a little bit about the impact of the increase in leaks in Prince George's County on the resources. You can kind of look at the intersection of where the resources needed to respond to Prince George's County and to support the massive replacement effort we undertook, intersected with the resources that would participate in mercury service regulator work. So by and large, they are meter and regulator technicians who also are, as a rule, qualified in emergency response. So as we're dealing with the incoming odor responses, we are having to pull on every resource available.
Excuse me, this is the reporter. I'm sorry, but I lost my audio again. I'm going to use a different phone tomorrow. Commissioner Linton was saying, so when the company is handling the issue that happened in Prince George's County, and then it went.
Ah.
About a minute,
right.
Yeah.
Hopefully that was a good enough question.
I will definitely be using a different phone tomorrow because this phone is acting up.
Well, that's not a problem, Linda. I'm happy to restate the question.
Well, I'm sorry.
No problem. And Mr. Murphy knows what's coming, so that's helpful for him too. For the question I had was regarding the company's reallocation of resources during the period of time that the leaks were occurring in the Prince George's County area. My question was, did the company also reallocate resources from other programs? And part B to that question was, if so, provide some examples.
Yeah, I was about to explain that, to really understand what's going on, it's helpful to look at the intersection between the resources that were doing the mercury service regulator replacement work and the resources that were needed to address the increase in odor complaints coming in, so emergency response work, as well as work associated with the massive replacement effort that we undertook. And those same resources were pulled in those two directions. So by and large, the shift was to the issue in Prince George's County. And the reason I'm sharing all that is I can't, as I sit here, think of another initiative that was underway that demanded, that kind of pulled at that same resource base. I'm sure there were other programs that were, maybe more financially demanding that had to be ratcheted back. But the most relevant to me is really where the common resources were pulled in two directions. And I just can't think of a program that had that effect.
Okay, is it your testimony today then that there were no other programs, or is that it's something that if you had you know, a day or so to take a look at some old information, you could find examples.
I wouldn't feel confident saying that there were no other programs that were affected.
Okay.
So I guess it would take some time to give a full answer.
Okay. All right. Thank you, Mr. Chairman. I considered a request on the record for it, but I'm not sure that that's, from a time perspective, something that would be useful for us. So I'll stop there. Thank you, Mr. Chairman. Thank you, Mr. Murphy.
Thank you, sir.
At this time, I'll recognize Commissioner Herman.
Thank you, Mr. Chairman. Mr. Murphy, I understand that you're testifying on what the current estimates of the MSRs are in service are. Can you give me that number?
Commissioner, I'm not sure I am testifying to that. We don't have a estimate that is, to my knowledge, we don't have an estimate that we consider reliable, which is why we are undertaking a survey effort to more definitively scope the replacement.
Okay, so you don't have an estimate right now. When will you have an estimate?
The intelligence will build as we get started with the inspection program, with the survey program. Charles Jackson is prepared to speak on the time frame for getting that kicked off and underway.
Okay, so how is it we have discussion about 74% of estimated MSRs and somewhere else there's 80%. How is it if we don't know how many there are that we have estimates of, that we're claiming that we've replaced 80% of them?
So I would read that 74% differently. That 74% was meant to express of the number that was committed to in the, that was described, not committed to, in testimony in 8959, how many did we actually get done? And we've got, in that 10-year period, we got 4% done in revenue. So if the company's being judged on how well it proceeded and acted according to its stated intention, we got 74% of what we intended to do.
Okay, thanks. Mr. Murphy, on page 7 of your direct testimony, at the top of the page, under summary of your position, you say that the company's plans for management of an MSR replacement activities within 5 years are reasonable and appropriate. I assume that's the plan that Mr. Jackson is talking about?
That's correct.
And is that also the plan that was submitted to Mr. Clemenson in August of 2019?
Honestly, I'd have to check that. That was the exhibit I was discussing with the attorney for OPC.
I can tell you, I believe it is company exhibit. Sorry, I have to pull it up here. Exhibits. Under my list, it's WGL Exhibit A. It's called labeled Attachment 6.
Yeah, I have it. And the program is described under recommendation 3.
So it's the same that what Mr. Jackson describes is what's in recommendation 3. I can ask Mr. Jackson that too. I was just curious, but
He'd be the better witness. I
Okay,
apologize.
that's fine. So with respect to the company's plan that you say is reasonable and appropriate, if the commission accepts that plan as submitted by the company, is that a commitment on behalf of Washington Gas?
You know, it is if we collectively decide it is. You know, just as other regulatory programs involve, replacement programs involve some level of uncertainty. Unfortunately, it's not a recipe we can write and a cake we can bake that will come out 100% the way expected. So I think, as Witness Reed said, reporting is very important. That's what's going to keep us on the same page. If we are communicating and sharing any changes that we may be subject to, we can head them off and decide is a variance to the program the right thing for a certain set of developments, or the wrong thing, figure out a way around it. And you know, so you know, we are committing to act again, once again, as we did in 2002, committing to act on our stated intentions. We only know what we know right now, and we're going to pursue it to the best of our ability. And I am confident we will do a better job communicating and reporting going forward.
I asked the same question to Mr. Reed. I'm sure you heard me. And I think the answer I got from Mr. Reed was no. It wouldn't be a commitment. It would be acting on, as you said, acting on the stated intention, but not a commitment. Do you agree with that?
Commissioner, that does sound like something that's being asked in the context of either the regulatory view of a commitment or a legal view. And I'm probably not your guy. I would say that if the company is stating its intention to do this, we are committed to act on that intention and use all the prudent judgment we can muster to deal with changes along the way and be communicative throughout.
Okay. Thank you very much, Mr. Murphy. I don't have any other questions. Thank you, Mr. Chairman.
Commissioner, we'll return to Commissioner Linton.
Thank you, Mr. Chairman. And sorry, Mr. Murphy, I had one other question I forgot to ask you regarding your exhibit 01 and 02. You've broken them out according to year, and for each of the rows that you have here, my question is, if I were to add another column onto your exhibit 02, would I be able to move the data from 01 directly over, or are they not aligned by year?
Sorry, bear with me just a moment. Add another column to 02?
02, correct. So currently you have in 01, you have the mercury regulator disposals by year. And in 02, you have other information related to the expense account totals and the amount of expense accounts attributable to Maryland. I was just trying to see if the disposals that are listed, like just as an example, in 2007, you had 5,073 disposals. Would that match to the fiscal year 2007, or does it match to fiscal year 2006?
It is shifted with just 3 months, so it's reasonable for the purpose of performing estimating to match them up.
Okay. All right. So in 06 and 07, then it's according to 02, 92% and 94% respectively of the MSR expense account totals were attributable to Maryland, as opposed to the other jurisdictions where WGL operates.
That's correct. And I would, subject to check, anticipate that may have been associated, Nope, that would be a question for Mr. Ternavy. I'm gonna roll that back. If you have specific questions about how those percentages rolled out, that might be a better question for Bob.
Okay. Well, that actually helps then. I'll save some additional questions I might have had for Ms. Boyette. Thank you very much, Mr. Murphy. Thank you, Mr. Chairman, for a second bite.
Thank you.
Thank you, Commissioner. At this time, do council have any questions based on the commissioner's questioning? I'll start with Mr. Buckley. Mr. Buckley, are you on mute? I'll move to the other parties.
No questions from OPC, Your Honor.
No question.
Staff has no questions.
Thank you, Mr. Dean. One more opportunity for Washington Gas Light. Do we have council?
Yes, thank you, Your Honor. It was while I was trying to press the unmute button, somebody in the control of the system was pressing it at the same time, so it was flashing. In any event, I just have one real quick, brief follow-up on Commissioner Herman's question in advance of Mr. Jackson getting a full swing at the prospective programs plan and its pace. So, Mr. Murphy, could you take a look at that company Exhibit A that was referred to? This is the letter from Stephen Price to Mr. Clemenson.
Yes, I have it.
And this relates to the pace of the replacement identified in that letter versus the pace in the prospective plan that the company has put in its testimony now.
Yes.
So if you look at the bottom of page 4 of that letter,
I see it.
you see that there's an estimated completion time to complete the survey of 3 years and replace the targeted inside regulators over 5 years.
Yes, I believe, in taking a second look at that, I believe in the company's testimony, we have accelerated that to a 1-year survey and a 3-year replacement for multifamily.
So in addition to that acceleration, has the company also broadened the scope of replacements to beyond inside regulators?
Yes, it has. The company intends, through the course of its survey and replacement activities, to get all mercury regulators, including any it finds in an outdoor meter buildup.
Thank you, Ron. That's all I have. Mr. Chairman, you're unmuted, I think.
Sorry. Thank you, Mr. Buckley. Thank you, Witness Murphy, for your testimony today. You are excused at this point. I may step down. We're going to take a brief recess to 4:25 p.m., at which point we'll hear testimony from Witness Jackson. We're in recess till 4:25.
Thank you.
We will be back on the record in 30 seconds. This is the continuation of the administrative trial in case number 9622. This will be the last witness that will be called for today. Mr. Buckley, please call your next witness.
Actually, Your Honor, I'll be handling Mr. Jackson, so with your permission, I will call him to the stand and ask that he be sworn.
Thank you. Mr. Jackson, if you could turn on your microphone and camera and please raise your right hand. Madam Court Reporter, are you with us?
Can you hear me now?
We can, yes.
Okay. Okay, sir, do you swear and affirm under the penalties of perjury that the testimony you're about to give in the matter now pending is the truth, the whole truth, and nothing but the truth?
Yes.
Please proceed.
Thank you, Your Honor. Good afternoon, Mr. Jackson. Can you hear me okay?
I can hear you very well, Mr. Dodge.
Thank you. Could you please provide your name and business address for the record?
Charles A. Jackson, 6801 Industrial Road in Springfield, Virginia.
And by whom are you employed, sir?
Washington Gas.
And your title, please.
Director of Service Operations.
Did you cause to be filed in this case direct testimony dated August 7th, 2020?
Yes.
Am I correct that your direct testimony consists of 9 pages of narrative questions and answers?
Yes.
Am I also correct that your testimony includes a single... am I also correct that your direct testimony includes a single exhibit?
All right, Dodge. Mr. Dean, your microphone is open. Or the host, there we go. Thank you. Sorry, Mr. Dodge.
No worries, Your Honor. Thank you. Does your direct testimony also include confidential exhibit CAJ-1?
Yes, it does.
At this time, do you have any corrections to your direct testimony or your confidential exhibit?
I do not.
If I ask you, Mr. Jackson, the questions in your direct testimony, would your answers be the same today?
They would be.
Do you adopt the pre-filed direct testimony and exhibit as your sworn testimony in this matter?
Yes, I do.
Mr. Jackson is available for cross-examination, Your Honor.
Thank you. Mr. Caldwell, you may begin if you have questions.
2 questions, Your Honor. Thank you very much. Good afternoon, Mr. Jackson.
Good afternoon, Mr. Caldwell.
Thank you. Mr. Jackson, would it be a fair assessment to say that your testimony describes the current and future plans of Washington Gas to replace the remaining mercury regulators?
That's exactly what it says.
Okay, thank you. So what happens if those plans change?
So we would, as shown here in the plans, we would be planning to file a report, and we would work with the commission on, file that report with the commission, and then we would discuss if whatever needs to change from there.
Okay, thank you. At page 7 of your testimony, lines 21 through 24. Let me know when you're there.
Yep, I'm there.
You state that Washington Gas is not providing a formal estimate of the number of regulators remaining on the system because the company does not have specific records to support a formal estimate, nor was the company required to maintain such records. Is that what it says?
That is what it says.
Okay. Do you have a copy of, or can you get a copy of OPC Exhibit 7, which was the annual status report? Filed.
Yeah, I have it. Hold on one second.
Okay.
Okay.
So if the report had been, only one report's been filed, if specified in the settlement agreement, wouldn't Washington Gas be in a better position to provide a formal estimate of the number of regulators remaining on the system?
I can't speak to that. I don't know how anybody came up with their estimates in previous cases, and I'm not speaking to that.
Well, but doesn't the exhibit list the number of regulators?
Can you rephrase your question?
Doesn't the exhibit OPC number 7 lists the number of regulators on, that have been replaced.
I believe that the exhibit says that over 22,744 mercury regulators were replaced.
Correct.
Okay.
So if Washington Gas had filed a report like this in the intervening years, over a 10-year period, Washington Gas would be in a better position to estimate the number of regulators on the system, would it not?
So the 2744 is just related to whatever estimate was provided previously.
Okay, I'm sorry, I'm lost. Where do you see the 2744?
In the OPC Exhibit 7, the third bullet.
Okay. Thank you. And so, again, if they had filed a report in years 2 through 8, where they had that same information, or they were updating the information on the number of regulators that were replaced, to estimate how many regulators remain on the system. Is that correct?
I don't know that that's correct.
Okay, can you explain why that's not correct?
So I would say that the 2,700, the report states that 2,744 regulators were replaced, and it provides whatever that estimate of possible locations may be. I don't know how they came up with the number, and I don't know how they were tracking replacements.
Okay.
Nor do I know what a hypothetical report might have done.
Well, it's not going to be. And so, are you questioning the veracity? Are you questioning what the accuracy of this report?
Objection, Your Honor. Mischaracterizes the testimony.
I'm asking a question. I'm sorry, Your Honor.
Mr. Caldwell, it appears you were questioning the veracity of the report. And Mr. Jackson has stated multiple times he doesn't know any better in order to provide an answer to your question.
Thank you, Your Honor. I'll try one more time. Is your testimony that this report, if it were filed, as the company committed on an annual basis over 10 years, that would not inform the current estimate of the number of regulators on the company system?
I don't know anywhere that this is in my testimony.
Well,
Mr. Jackson, if it may not be in your testimony, but can you answer that question from Mr. Caldwell?
Can you repeat the question?
Yeah, sure. Well, let me direct you to the testimony first. At page 7, lines 21 through 24.
Okay.
You say the company is not providing a formal estimate of the number of regulators remaining on the system. You see that?
I see that. It's written there.
Okay. All right. So all I'm asking is, armed with a report like this over a 10-year period, wouldn't the company be in a better position to estimate the number of regulators remaining on the company system?
You'd have to go back and try to figure out how they came up with their estimate. I don't know.
Nope. I'm asking you to assume that in years 2 through 10, the company continued to file reports as it committed to do in case 8920. They filed one report. They committed to file 10 reports on an annual basis. If they had done that, wouldn't the company today be in a better position to estimate the number of regulators on the system?
It would know how many it had replaced based upon that estimate.
Okay. Thank you, Your Honor. I have nothing further. Thank you, Mr. Jackson.
No, thank you, Mr. Caldwell.
Thank you. Mr. Cleaver, your witness.
Thank you, Your Honor. Good afternoon, Mr. Jackson. My name is Joe Cleaver. I'm from the Office of People's Counsel. I just wanted to ask you about one sentence in your testimony and then a follow-up data request that I sent to the company based on that sentence. The sentence I'm talking about, if you could turn to your direct testimony at page 3, line 18. Tell me when you're there.
I am there.
You state here that if Washington Gas discovers a mercury service regulator during unplanned activity, such as a response to an odor call or other service request, that mercury service regulator is flagged as a location that has a mercury service regulator for possible change out at a future date. Did I read that correctly?
That's what it says.
Okay. And now could I refer you to what's been marked as OPC Exhibit 17, which is the company's response to OPC Data Request 6-1 in this docket, case 9622. Right, tell me when you're there.
I am there.
Okay. And this question specifically asked about that statement, and then asked a number of sub-questions. And you were the sponsor of the answers to all these sub-questions, correct?
I was the sponsor.
Okay. Well, the first question that's asked there is how long the practice has been in place. And you state that, if I'm looking down at your response to subpart A, that the O&M manual revision stating mercury sealed regulators remaining in service shall be appropriately documented in CAD became effective 6/25/2007. Is that right?
That is what it says.
Right. And could you just state for the record, what does the acronym CAD stand for?
I believe it computer aided dispatch.
Okay. And then, thank you. And then I would like to ask you if you could take a look at sub-question C that asks, again, referring back to this quote from your testimony that we read, it asks to please describe in detail what it means for a location to be flagged, including how that process conveys the need for a possible change out at a future date to the relevant division of Washington Gas. And then you answer here and you explain that technicians trained to identify MSRs select one of the following options in the work management system. The selected options captured as part of the record of the executed order. And then these records can be taken into consideration when planning MSR replacement activities. And then there are 5 different options. The first says found a mercury regulator but did not change. The second one says there is no mercury regulator at the premises. The third is an option to indicate if the meter buildup is not accessible. The fourth is if the mercury regulator was changed. And the fifth is if it's not applicable, if it's a low pressure service. So let me ask you this question. And when you, referring back to subpart A, this is the coding system, so to speak, that's been in place since 2007. Is that right?
That's not correct.
That's not correct. Okay. How long has this coding system here that's described in subpart C been in place?
I would have to check. It is, I believe, in the response to either the commission or the NTSB.
Okay, let me ask you this. This revision, referring back to your answer to subpart A, stating that mercury sealed regulators remaining in service shall be appropriately documented in CAD. Does that documentation look different than what is reflected here in the response to subpart C?
In terms of language, yes.
So if I understand your answer correctly, were the changes that were affected on June 25th of 2007, that simply required technicians that encountered mercury service regulators to document them, but didn't change the manner in which they were documented. Is that right?
I don't know the intention of the 2007 implementation.
Okay. Well, let me ask you this. Let me ask this question then. These 5 options set forth in subsection C. This is still what's presently in effect when technicians document work, when they identify an MSR. These are the 5 options that are still available in terms of documenting it. Is that right?
So a technician working in the customer information work management system has these options.
Okay. So if a technician, if looking at the very first option here, if a technician presently encounters a mercury service regulator in the field, there's no requirement that the regulator be changed immediately or under any other time frame. Is that fair to say?
It would depend upon the reason they're encountering it.
Okay. Well, let me ask you, maybe it'll help the discussion here if I go on and just ask you about subpart D. The question, again, referring back to that sentence from your testimony, with respect to the fact that such a change out is only possible, please describe what factors the company applies to determine whether an MSR that has been identified in the field will or will not actually be replaced. And then going down to your answer to subpart D, you say here that the company does not make a determination whether to replace MSRs. All MSRs will be removed from service when any of the following conditions are met. And it sets forth 6 conditions. If none of these 6 bulleted conditions are met, does this answer when it says the company doesn't make a determination if one of these 6 things are met? Does that mean that if none of these 6 are met, that the company does not at present replace the mercury service regulator?
Yes, if it's not meeting one of these 6 requirements.
Okay.
On an unplanned basis.
Unplanned basis. I see. So these 6 requirements are what's necessary. Sorry, just got this data response yesterday, so still digesting it. These six conditions are the guiding standard for when an MSR is encountered in the course of unplanned activity. If any of these are met, you'll replace it. Separate and apart from that, there are planned mercury service regulator replacements. Is that fair to say?
There could be.
Okay. Does the company, let's just take the year, a recent year, but before the correspondence regarding the new plan. Let's take the year, say 2018. If you know, did the company in 2018 have any kind of planned MSR replacement activities underway?
If they would have been related to, say, a stride replacement or that's generally how the planned go.
Okay, yeah, and my understanding is that the company will, if it's doing stride work and there's an MSR present, that it'll be replaced as part of that activity. Is that fair to say?
That is fair to say.
Other than stride activities, are there any other planned MSR replacement activities?
Yeah, well, I guess that might be unplanned, but if a customer requests a mercury regulator replacement, then that's somewhat planned, but not initially planned.
Okay, so at present, unless there's a stride work being done at a home, if a mercury service regulator is somehow encountered, it wouldn't be replaced unless one of these 6 bulleted conditions set forth here in subpart D are met. Is that right?
In terms of unplanned work.
Do you know how long that practice has been in place?
I do not. It's been in practice for as much as I've known.
Okay. Thank you very much, Mr. Jackson. Your Honor, I don't have any further questions for the witness. I would ask that what's been marked, pre-marked as OPC Exhibit 17, which is the company's response to OPC Data Request 6-1, be moved into the evidentiary record in the case.
The exhibit is so marked. Seeing no objection, OPC Exhibit number 17 is moved into evidence. Mr. Dean, your witness.
Good afternoon, Mr. Jackson. I'm Michael Dean from the staff.
Good afternoon.
I just have a few questions here. On pages 5 through 6 of your direct, you discuss the issuance of a RFP. Do you have any updates regarding the status of the RFP and of obtaining a contract, the specified work?
Are you, which RFP are you referencing?
The latest one that was issued.
Okay, yeah, so we're currently doing our due diligence with our bidders, you know, the checking pricing, checking references, and you know, we hope to have a finalization soon.
Okay, it can be a problem.
Thank you very much. Could you describe the replacement procedure for a mercury service regulator and include whether there's any difference between a indoor or outdoor regulator?
Okay, so I actually think Mr. Murphy described it pretty well when he said it, but you know, generally the difference being that there's a device where a technician takes a reading to make sure there isn't the presence of mercury. They put down some matting. They put a bucket underneath the regulator to help, just in case there were any spilled mercury, with a bag in it, and then they, you know, lower the regulator into the bucket and then seal it. Whereas that's not necessary for a regulator, but otherwise identical.
Thank you. Are most Stride contractor crews trained in this replacement method?
I'm sorry, can you repeat your question?
Yes. Are most of the Stride contractor crews trained in this method?
So I would so two different types of work streams here. You've got your underground Stride crews who would not be trained in doing this, mercury regulator replacement. And then you would have your above ground meter and regulator style contractors. To say most, I don't know the number, but any meter and regulator contractor who would remove or replace a mercury regulator would be qualified to do it.
Thank you very much. And the last question on page 9 of your direct testimony, lines 13 through 19. Are the dates listed here still accurate?
So we are still, yes, intending to do a 1-year survey consistent with our prior representations. You know, we will initiate our 3- and 5-year replacement programs at the close of the 1-year survey. That way we can use those survey results to inform, you know, which geographic areas may host the replacement activity first, and then we will also use those survey results to inform, you know, continuing our replacements during the 1-year survey.
Thank you very much. Staff has no further questions.
Thank you, Mr. Dean. Mr. Dodge.
No follow-up questions, Your Honor, but I neglected to mark Mr. Jackson's testimony as WGL Exhibit 5, and I would do that now and move its admission.
Yes, Mr. Jackson's direct is so marked as WGL Exhibit 5 and moved into evidence. Do commissioners have questions of the witness? Seeing None. The witness is excused.
Nope.
I'm sorry, is it too late?
Oh, Commissioner Richard, do you have a question?
Yeah, just I was interested in. I was going to actually text you and say if you want to let someone else go first, that would be fine. So, but anyway, I just wanted to ask first about the recommendation of, and I believe it's the Office of People Counsel with regards to the MSRRP, the upcoming one. They have a number of there's a number of filing recommendations and also just a series of deadlines with penalties attached. Do you have any thoughts on those, or any do you support that? Would you accept that, or just give me your any input you might have on those recommendations?
Sure, Your Honor. I don't claim to be any type of expert in what penalties or shouldn't be applied. I would say that we would continue to work with the commission staff or OPC about what reporting requirements should be. We want to make sure that we're fully informing here, and that we would work on any changes there.
Okay. And I guess the only other, if I'm reading maybe a concern of staff, the commission staff correctly, it just seems like as we're looking at how the company plans to move forward at this stage, we don't really seem to have a lot of information. We don't know when the survey is going to begin, and then when the MSRRP is going to pick up. We don't really have any cost estimates. When will we have that information?
As soon as we are ready to issue a winning bid, we want to make sure we're doing our due diligence here to make sure we choose a contractor that we're confident with that can get the survey done. We don't want to go forward without that. So we would know by that time, once we sign a contract, what their pricing is, and so we would be informed of what an estimated survey would cost. And then once we start seeing the results of that survey, we could then start forming some intelligence into how many regulators may be out there and how much those may cost to replace.
Okay, and I understand that with the whole COVID pandemic situation, it's made it much more complicated to move things forward. But I think that might be. Yeah, I'll go ahead and stop there. Thank you, Mr. Chairman.
Thank you. Witness Jackson, you are now excused. Commissioner Linton, sorry.
Thank you. Sorry, mine are really quick, actually. I'm at
Objection. No.
Overruled. No.
Mr. Jackson, next time I say you're excused, you should just log off the system.
No, it's good. I enjoy this.
These are actually pretty simple ones. I'm looking for, just to follow up on Mr. Dean and Commissioner Richards' questions. On the bottom of page 6, you have a date of October 1st for when the surveys can commence. So that's in your direct testimony. I'm assuming that that date is not accurate, or that the company is not prepared to move forward on October 1st with surveys.
That was accurate when I wrote my testimony. And so, yes, we have seen some slippage of this date, likely about 4 to 6 weeks. And I would expect, obviously, having a finalized contract in place would be more beneficial, but likely more November.
Okay, and so what about the higher confidence locations? You in that same bottom of page 6, top of page 7, you stated that would start in August of 2020. That date has also changed?
We've already started those this week.
You have started those? Okay.
Yes.
Okay. And that was it. Thank you, Mr. Chair. Thank you, Mr. Jackson.
Okay.
I do have one follow-up from Commissioner Linton's excellent questions. Mr. Jackson, listen carefully to this, please. Will Washington Gas file the completed survey RFP with the Commission?
Yes.
That's all I have. Thank you, Your Honor.
Thank you. Before we adjourn for the day, and reconvene tomorrow at 10 a.m. Does council have any additional matters that we need to address before we adjourn this evening?
If I might have a moment to consult with Mr. Buckley, I think we're all set, but just give us 30 seconds, please.
Yes.
Can be faster than that. Nothing for me.
And we have nothing, Your Honor. Thank you.
Very good. Thank you. We will pick up tomorrow morning at 10 a.m. with witness Turamini. With that, this hearing is in recess until 10 a.m. tomorrow, September 25th. Have a good evening.
Thank you.
Good night.